There are two sisters, my lord.
Heard, Mr. J.U.N.M. Laskar, Learned Counsel for the petitioner. In this petition under Section 24 of the Code of Civil Procedure, the petitioner has tried for transferring title or restitution suit number 2 of 2026 under Section 9 of the Hindu Marriage Act 1955, pending before the Court of Learned District Judge Ceremony to the Court of Learned Principal Judge Family Court, Kasar at Silsar. Mr. Laskar, Learned Counsel for the petitioner, submits that the petitioner is the wife of the respondent wife of the sole respondent who has instituted title or restitution suit number 2 of 2026 under Section 7 of the Hindu Marriage Act before the Court of Learned District Judge Ceremony. But he submits that the petitioner herein is residing at Silsor in her parental abode, and there is none to accompany her to ceremony to contest the aforementioned proceeding before the Court of Learned District Judge. And on such ground, there is a requirement of transferring the aforementioned suit from the Court of Learned District Judge Ceremony to the Court of Learned Principal Judge Family Court, Kasar Silsor. The submission of Mr. Laskar needs further consideration at this stage. Notice be issued to the respondent, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks. At what is this? The proceeding is pending.
My lord. That notice was appearance team, my lord.
Appearance.
Appearance team.
Okay. Interim prayer of the petitioner will be considered on next returnable date.
Till then, my lord.
Let the other side appear. We will consider your prayer.
Obliged.
Lord, this arises out of a rejection of an application for adducing expert evidence. The dispute, my lord, was relating to agreement at Annexure 3, page 28. There was a monetary transaction between the parties, which was subsequently dishonored and which resulted in the filing of the suit. Now, the core issue, my lord, which had come up before the court in the application for, my lord, adducing expert evidence is that the signature of the defendant, my lord, who is the respondent herein, he had denied that he had not signed this agreement.
What is this? The proceeding is pending now?
My lord, unfortunately, it is in the stage of hearing, my lord, and admittedly,
Hearing
my
or
lord,
argument?
my lord, it's fixed for argument on 8th of May, my lord. The application was admittedly, my lord, again filed after cross-examination of DW. When DW said that, my lord, at page 44, he said that I deny my signature herein, and I am ready to face the required forensic examination of my signature. Thereafter, the application was filed, my lord. Of course, ought to have been filed probably earlier also. But then, my lord, these are matters relating to procedure, my lords, which are to be seen as a handsmaid of justice, my lord. But then, learned court, what order has been passed, my lord. Para 9 of that particular order, if your lordship sees, the learned court had gone into the aspect of relevancy of, my lord, expert evidence, which of course is a issue, my lord. It is that expert evidence cannot itself be conclusive, but that does not mean that it can be ruled out altogether, my lord. If your lordship look at the interim order at page.
What is your stand?
Page 20, para 9, my lord.
No, Mr. Pathak.
Petition that is filed after taking several adjournments for argument.
How many adjournments were taken?
3 adjournments were taken by the court
3 adjournments.
for hearing for a final hearing of the argument of the case. Thereafter, suddenly they have come with these petitions. So, it means DW hearing completed. So
No, Mr. Sharma, you see, the argument is not yet completed or heard.
Not comments.
So now
Then where is the infirmity in the, no, okay. Then what is your objection?
My lord, first of all, objection is that, my friend, they have brought one check is there and one agreement is there. In both pieces, there are two initials, just initials. So my lord, they want to say that those initials in the agreement should be verified with initial signature. It is not that those should be verified with first signature. Their petition, petition is they have not filed the petition before the note of vote.
Hmm.
Petition should have been there. Neither their petition is here, no objection will be able to.
Mr. Pathak, it is not part of the record.
Those should have been filed first. I think why they have forgot it.
Mr. Pathak,
My lord, I think we did not receive the certified copies till now, my lord. Subsequently, it has come, my lord. Because we had this constraint of 90 days again for filing.
Talk to the notice. Whatever there is. the petition.
better
Subsequently, I have received the copies.
you
my
bring the same on record by filing an affidavit.
My lord, my lord.
Heard Mr. B. Pathak, learned counsel for the petition. And Mr. Sharma, learned counsel for the respondent. During the course of hearing, Mr. Sharma has pointed out that the petitioner hearing has not enclosed the petition number 4427 of 2025 and also the objection filed by the respondent hearing in the said petition. Mr. Pathak submits that he may be granted some time to bring the same on record by filing an additional affidavit. Parallel, rest is less the matter. Within a week,
My lord, we did not.
call.
6th May.
Can it be on 5th, my lord?
What is it? On Wednesday or Friday. Around 8.
The 6th to 8th, I'm not available otherwise, my lord. We can try on 5th, my lord. Shout issue. 11.
I don't agree.
So, Bhuya, you were supposed to file one
Lordship.
decision
Lordship.
of the Supreme Court.
In this regard, Your Lordship, I want to submit one thing. There is a landmark decision of this Honorable Apex Court, Kala Devi, as Kala Devi versus Veer Thomas. Your Lordship, this is basically based on Section 49 of the Registration Act. Para 10, Your Lordship. Lordship got it. Paragraph number 10.
Yes.
Section 17 of 1900 Act, this is a Registration Act, Lordship, is a disabling section. The documents defined in a class A to E therein where require registration compulsory. Accordingly, sale of immovable property of the value of rupees 100 and more requires compulsory registration. Part 10 of 1908 Act deals with the effect of registration and non-registration. Section 49 gives teeth of Section 17 of providing effect of non-registration of a document requires to be registered. Section 49 reads thus, Section 49, effect of non-registration of a document required to be registered. No document required by Section 17 or by any provision of the Transfer of Property Act to be registered shall A, affect any immovable property comprised therein, B, confer any power to adopt, C, be received as evidence of any transaction affecting such property or conferring such power unless it has been registered, provided that an unregistered document affecting immovable property and required by this act or the Transfer of Property Act to be registered may be received as evidence of a contract in a suit for specific purpose under Chapter 10 of the Specific Relief Act, or as evidence or any collateral transaction not required to be affected by registered instrument. So, para 11, Lordship, the main provisions of provision in section 49 provides that any document which is required to be registered, if not registered, shall not affect any immovable property comprised therein, nor such documents shall be received as evidence of any transaction affecting such property. Proviso, however, would show that an unregistered document affecting immovable property and required by so-and-so Act of Transfer of Property Act so-and-so to be registered may be received as an evidence to the contract of a suit of specific purpose or as an evidence of any collateral transaction not required to be effected by registered instrument. By virtue of proviso, therefore, an unregistered sale deed of an immovable property of a value of ₹100 and more could be admitted in evidence as evidence of a contract in a suit for specific purpose of contract. So, Lordship, that is admittedly, I am submitting before the Honorable Court that I cannot acquire right title on the basis of unregistered sale deed. What remedy open for me? Only remedy open for me to seek specific purpose of contract. So that is why that application was filed. So only one option is open to the petitioner plaintiff to seek relief as per proviso of section 49. So under that circumstances, this application was filed. But the learned trial court, Lordship, that they rejected my application, holding that my application is time barred. So whether that question can be decided by the learned trial court, section 49, para 19.
At what instance the proceeding is pending?
Lordship, issue has been framed and SBPH.
Okay. Okay, we will go through this decision and we will pass the order.
Lordship. And so far the limitation point is Lordship concerned as held by the learned trial court. There is a relevant, there is a citation of Honorable Apex Court 2008 4 SCC 102
Limitation for
limitation. Whether the question of limitation can be decided at the time of amendment above application. The Honorable Apex Court says, no, it cannot be. So that citation has been carried.
which is the relevant paragraph here?
Relevant paragraph is paragraph 13, Your Lordship. Paragraph 13.
Okay.
Look.
Item 4,
Lordship, interim order is till today.
Okay, we will pass the order.
Lordship. May please, Your Lordship. My Lord, by way of this revision petition, I am assailing the impugned order dated 31/3/2026 passed in a petition filed under Order 9, Rule 13, whereby the petition was allowed. So, my Lord, against that order allowing the petition under Order 9, Rule 13, I am before this honorable court under 115, under section 115 of the code. Your
No,
Lordship will
Mr.
kindly
Chakravarti,
my Lord.
you see, in the impugned order, the trial court has recorded a finding
My Lord.
that someone was not properly served.
My Lord.
Then how the impugned order is illegal or arbitrary?
My Lord. Your Lordship kindly sees in so far as arriving at the findings to the extent that this summon was not served, the same very court, while taking up the trial of the suit in an order dated, in an order passed in 2018, had arrived at a specific finding that the process server has submitted the report as per which the summons were served. Now that order
was never put under challenge in the petition under Order 9 Rule 13 by the applicant.
That order is part of the record.
That order is in respect of the suit,
No, is it a part of this record?
the record of the revision petition.
Yes.
No. That order, I have taken a plea, specific plea in my grounds and in my plea.
You have taken a plea, that all right, but in support of your plea,
My lord,
you have to submit that.
regarding that order,
Yeah.
my lord, that can be done. That apart, my lord, insofar as the finding of the learned court below, insofar as the non-serving of summons upon the applicant in the Order 9 Rule 13 petition. Now, to that extent, my lord, there has to be a procedure followed where the process server will have to be examined. Now, the process server was never brought on the docs for examining as to whether the summons were served properly or not. Now that the issue regarding non-serving of summons was raised by the applicant, who is the respondent here. Now, it was her bounden duty to have filed a petition requiring the process server to be examined. That process was never followed, my lord. In my humble conviction.
But it appears that the court has compared the signature of the respondent herein with the petition
My lord,
and the
here,
Hazira.
yes, here, my lord, my humble submission here. The honorable, the learned trial court
Mm,
stepped into the shoes of an expert,
mm,
where comparing of signatures and arriving at a conclusion that the signatures are not same or the signatures are different,
mm.
that perhaps could not have been possible on the part of the learned court below, which perhaps is the prerogative of an expert, the FSL.
No. The act provides for comparison.
My lord, that comparison is there,
Hmm.
but your lordship, vis-a-vis the fact that once the after comparison,
Mm,
if the and in the cross-examination of the applicant under Order 9 Rule 13,
mm,
she has admitted to all other aspects regarding the institution of the suit, regarding the fact that she knew that her brother had entered into her deceased brother had entered into an agreement with the petitioners herein, the plaintiffs in the suit, and that the contract was to be performed, and eventually it led to an ex parte judgment and decree. Whereby the specific performance of contract was allowed. Now, all these aspects were very much within the knowledge of the applicant under Order 9 Rule 13 petition. But she, after a decree of 2018, after 4 years, my lord,
Mm.
in 2022, before that, in 2020, the decree was put to execution, entitled execution case,
Mm.
filed by the plaintiffs.
Mm.
I have annexed the petition, execution petition.
Mm.
Now, in the execution petition also, notices went, but she did not turn up. And her own sibling, she never contested the suit earlier and she never came.
No, Mr. Chakraborty,
My lord.
we are not married of the suit
My lord,
at this stage.
my lord, it is
We are
in,
concerned with only
my
the
lord,
observation made by the trial court
my lord,
that someone was not properly served.
my lord. To that,
On the ground, on which ground it has vacated the ex parte order.
understand, my lord.
And your contention is that
Process server
same
was
very
not
court on earlier occasion observed that someone was duly served.
served, that order
And
was
that
never challenged.
finding is not available before this court.
I can produce
You
it.
bring it
I'll
on record.
do that, my lord. I'll do that.
When?
My lord, your lordship gives me a week's time. It has to
Week's
come from
time.
Kachar, so a week's time.
Heard, Mr. Chakraborty, Learned Counsel for the petitioner. This petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated. No, not 227, under section 115, read with section 151 of the Code of Civil Procedure. The petitioner has challenged the order dated 31/3/2026, passed by the learned civil judge, senior division number 2, Kasar Silsor in Miss J case number 50 of 2022, arising out of title suit number 98 of 2018. It is to be noted here that by impugned order dated so and so, the learned trial court has allowed the petition filed by the respondent, struck defendant number 2 under Order 9 Rule 13 CPC, and set aside the ex parte decree dated 20th 12/2018. passed in title suit number 98 of 2018. Mr. Chakraborty, learned counsel for the petitioner, submits that the petitioner, that the learned trial court has vacated the order expertise judgment and decree dated 20th to 2018 on the ground that someone was not properly served upon the defendant stroke respondent number
2.
Respondent number 2 herein. The respondent number 2.
No, respondent is sole
the-
respondent,
the-
defendant number
On
2.
the defendant number 2. Defendant number 2 in the title suit number. In the title suit number 98 of
No.
2018. But Mr. Chakraborty also submits that the same very court on earlier occasion has held that someone was properly served on the basis of the report of the process server. But Mr. Chakraborty submits that the said finding of the learned trial court is not enclosed with the present petition, and a price for granting him week time to bring the same on record. Pair allowed. List the matter next Monday.
I'll produce the certified copy, my lord.
Certificate.
Your lordship is fixing a date, my lord.
Monday. Next Monday.
Next Monday. To-
Court may-
my lord. Deeply aware.
Number 5.
May it please your lordship. My lord, the petitioner is the defendant in the suit and a tenant. My lord, he applies for filing an application for calling the NJ cases of monthly rents. Then, my lord, the impugn order comes where it says that you have said yourself as a licensee, so we will not call the NJ cases. That is why I am before your lordship. My lord, licensee is defined under Eastment Act, section 52. Eastment Act is not applicable here in state of Assam. So, my lord, question of licensee does not come when it is we are saying call for the NJ cases, we are depositing that the impugn order is at page 64.
Yes.
May I read it, my lord? Today was fixed for fresh hearing on petition number such filed by defendant praying for calling the NJ cases records and petition for amendment of petition number such. I deem fit to first take the petition for disposal. The petitioner defendant by petition stated they have been depositing the monthly rent from the month of November in the court, and as such, in order to prove the payment of rents, they have prayed for calling the NJ case records. The plaintiff opposite party has filed his routine objection in the aforesaid petition. The averments of the plaintiff opposite party are that the relationship between plaintiff opposite party and the defendant is not that of a landlord-tenant as provided under the Assam Urban Area Rent Control Act. According to the plaintiff opposite party, the existing relationship between plaintiff opposite party and the defendant are based on a leave and license agreement which expired on 30/11/21. According to the plaintiff opposite party, since the relationship between plaintiff opposite party and the defendant is not governed under the Urban Area Rent Control Act, as such, even if any deposit of rent is made by the defendant petitioner, the plaintiff opposite party has no connection with the same. To substantiate his averments, the learned counsel for the plaintiff petitioner has pointed out some of the statements made by the defendant opposite parties in the written statement where they admitted they are in possession of the suit premises paying monthly license fee, as admitted that the leave and license agreement expired on 30/11/21. Hence, according to the learned counsel for the plaintiff opposite party, in view of the admission made by the defendant in the written statement itself, the petition filed for calling the NJ case records ought to be rejected. My lord, para 10, upon hearing the prima facie, it appears the defendant admitted they are holding the premises license fees, which is leave and license agreement. The only contention of the learned counsel for the defendant opposite party is that the receipt that were issued by the plaintiff opposite party was written as monthly rent. In respect of my considered opinion, when the agreement on the basis of which the defendants are possessing the suit premises was itself a leave and license, but not a tenancy agreement, which is also admitted by the defendant in the written statement, under such circumstances, it cannot be assumed that only because it is written on a payment received as monthly rent, the interrelationship between parties will change into landlord-tenant relationship. Accordingly, admitted there is no landlord tenancy, hence the deposit of the rent in my considered will not be helpful to the defendant such and such. This is rejected. Leave and license, my lord, is Easement Act. Under section 52 of the Easement Act, which is not applicable, my lord, in lot of judgments it has been said.
But Mr. Roy Sodhuri,
My lord.
there exists one leave and license agreement between the parties.
My lord, in one of the judgment, what I find, my lord,
Mm.
it says, if it is written also, it will be a surplus. Because if it is lease also, under 105 of the Transfer of Property Act, because, my lord, subject to all my humiliation, my lord, the entry 18 to 10 schedule, my lord, the second list, where the landlord tenancy relationship will be governed by under 245 of the Constitution, under the state laws. The moment the state laws, there is an Urban Area Rent Control Act, Transfer of Property Act, Easement Act, whatever it is, it cannot be. The moment it is paid monthly, it will be Urban Area Rent Control Act. My lord, that was decided, my lord, in, first of all, my lord, I'm giving this judgment without. First, this, my lord, para 13, I'm writing, this is para 13, Gadao. And my lord, another judgment that is 79.4 SCC page 214, it again. Even if it is, my lord, there is a leave and license, but once it is paid as a monthly rent, it will be converted into Urban Area Rent Control Act. And it is from Gauhati under the Municipal Act, so it is covered under this. The judgment is done. This one. My lord, that Pachugopal Borua, that is para 13, where Easement Act is not applicable, it is written there, para 13. And my lord, that V.
Which
Dhanpal
one?
Chettiar,
Which one?
my lord, Pachugopal Borua, that is, and others.
You
Pachugopal
have
Borua,
not given that judgment?
Pachugopal Borua, you have not given? Pachu,
This is Kamal Datto and others versus
What was this?
Ranendra Das.
Pachugopal Borua is this one. What is the para 13, man. Para 13. And my lord, in V. Dhanpal Chettiar, that is V. Dhanpal Chettiar, my lord. Your lordship has got it, this V, where my last page, paragraph 18, last to last page, paragraph 18, last paragraph.
Paragraph number 18.
18, last paragraph.
If we.
If we agree, if we do it. And that's a thought you have. My lord, I'm placing this book, my lord. My lord, state list entry number 18. That is the state prerogative under Article 245, my lord. So the moment the state law is there, the central laws, my lord, article, constitution, state list, state, second list, entry number 18.
You say,
No, there is no dispute that it is in the state list.
My lord. My lord, the only issue, the moment there is a state act, my lord, as a Urban Area Rent Control Act, the concept of easement which is not applicable because they are saying lease and license. Lease and license is not applicable in the state of Assam. And my lord, they are wanting ejectment of from a shop where we are doing our business. There is the prayer. But they just only by saying leave and license. We have stated in our written statement, no, we are paying, there is no leave and license, monthly rent, we have stated in our written statement also.
Hmm.
My lord,
And,
only-
what is this? The suit is pending now.
my lord, because they will not be prejudiced. If the NJ cases will come before the trial court, that we are depositing the monthly rent, whatever it is, they will not be prejudiced in any way around.
No, that's all right. And what is this? The suit is pending now.
My lord,
At what
evidence
stage the
stage,
suit is-
evidence stage.
Evidence.
Evidence.
Evidence of?
It's not started. My friend saying it's not started yet. Evidence, but it will be, next will be evidence, but it has not started.
The plains and written statements are part of the record.
My lord, some of the written statement and the application, my lord, is at page 36, 37. And the plaint is also in the record, my lord. Plaint is in page, starts at page. I think it's 14, written statement, page 25. Page 14 is the, my lord, plaint. Their prayer is for suit for ejectment of defendant, prayer for area license fee. They cleverly has put an area license fee, my lord. And page 21, ejectment of defendants. And page 25, we have said there is a word of monthly rent also, is the written statement. And in my application under for calling the NJ cases is at page 37.
Which paragraph of the written statement it has been mentioned?
My lord, paragraph 1 only you also will find. There
Paragraph?
is 1 in written statement, page 25. There is no cause of action in view of the fact that defendants number who are running the business in the suit premises since 1918, initially as a lease, thereafter a tenant, and finally a licensee never refused to pay monthly license fee or monthly rent to the plaintiff. On refusal, take monthly license fee, and defendant number 1 deposit the same in the court since in the month of November 2021.
So your plea was that you were the licensee.
My lord, licensee by writing licensee, because licensee is defined under the Easement Act. My lord. Easement Act is
No,
not
that's all right,
applicable.
but it is your plea.
My lord, here we are saying or monthly rent also, my lord, or monthly rent. Because in reply to the plaint, I have
No,
to
you are not sure that whether you are licensee or you are a.
I am a tenant, my lord.
That-
I am a monthly tenant, because by conduct, by the way of the payment,
But your stand speaks both.
both, maybe my lord, some language problem is there, but my lord, the moment the conduct is that I am paying, depositing in the NJ cases before the trial trial court. So my lord, those records called upon will not prejudice the other side in any way. So only that much was called upon. And the court says the licensee. My lord, now to govern licensee, Easement Act, my lord, it is there. My lord, your lordship may look into the Easement Act, section 52, licensee defined. Easement Act this one? It is there. Section 52, my lord.
Yes.
Your lordship has got it, section 52, licensee defined. When one person grants to another or to a definite number of other persons a right to do or continue to do it upon the immovable property of the grantor, something which would, in the absence of such right, be unlawful, and such right does not amount to an easement or an interest in the property, the right is called a license. But this act is not applicable in the state of Assam. And in the monthly, the grant receipt, they have stated as a monthly rate. The impugn order itself says, they have stated that it is a monthly rate. The impugn order says, my lord, page 66, para 12. Para 12. In respect to the considered opinion, when the agreement on basis of defendant are possessing the suit premises, itself a leave-in license and not a tenancy agreement, which is also admitted by the defendant in the written statement. Under such circumstances, cannot be assumed that only it was written on the payment received as monthly rent, the entire relationship of parties will change to landlord tenancy agreement.
Okay, we'll see and pass the order. But you have taken contrary stand in the written statement.
My only contention is this before lordship, my lord. My lord, if the trial court brings the NGA cases, then itself may decide whether it is under the Easement Act or under the Urban Area Control Act. But calling for the,
How?
my lord, thereafter the trial court will decide whether the suit is at all maintainable under the Easement Act. If the Easement Act is not applicable, how could the suit be applicable, maintainable?
No, trial court has made the observation on the basis of the written statement filed by you.
But can on the basis of an statement where the act is not applicable, can it be made applicable in the state of Assam?
No, you have admitted it.
But they have also admitted in the monthly receipt that there is a monthly rate.
Okay, we'll say. Yes, next item.
Item 6.
May I please, Your Lordship? My lord, this is the application, my lord, against the order passed by the trial court, my lord, in the petition filed under order 11 rule 12, my lord. And the petitioner is the defendant number 1, my lord, in the suit. And my lord, the fact is, the plaintiff, my lord, the plaintiff and the defendant number 2 in the suit. Now, the mother of the plaintiff, my lord, during her lifetime, my lord, execute a sale deed in favor of the defendant number 1, my lord, the present petitioner, my lord, during her lifetime, and after his death, my lord, the plaintiff filed a suit saying that their mother expired before the execution of the sale deed. So in the death suit, my lord, petitioner contested by filing written statement. But the defendant number 2, my lord, the daughter of the, my lord, the original owner of the land, and the sister of the plaintiff, my lord, she appeared, contested the suit, but not filed his written statement. A written statement. So, my lord, this defendant number 1 filed a petition under order 11 rule 12 for calling, my lord, of the original death certificate which is in the custody of the defendant number 2.
So there are 2 death certificates.
Yes. Now, admittedly, my lord, that sale deed which is executed in my favor is a registered sale deed executed before the sub-register Dhing Nogam by the mother of the plaintiff and the defendant number 2.
Hmm.
Now death said it was executed and land was handed over to me. After her death, my lord, this plaintiff filed this suit by way of a my lord, death certificate, which is
Hmm.
procured manually, my lord, from the office, saying that their mother expired on 1/1/2008, whereas this sale deed was executed in 22/3/18.
Hmm.
And as per my statement in the WS, my lord, her mother was expired, my lord, on 10/4/18. So, and admittedly, my lord, the genuine death certificate is in the custody of defendant number 2, my lord. But she contested the suit not file his written statement, her written statement. So I have filed this petition under Order 12, Order 11, Rule 12 for calling of that document.
She has not filed a written statement.
Not, she contested but not filed a written statement. That's why, my lord, I have filed a petition under Order 11, Rule 12 for calling of that genuine death certificate, which is in her custody.
No, she has not filed her written statement, and that document will not advance her argument and her
No,
stand.
my lord, why I have filed this petition? Because that sale deed was executed by the defendant number 2 and her mother.
Hmm.
Possibly kindly see the impugn order. This is at page 40, my lord, the next 5.
So the petition number 1266 of 2025 was filed by the respondent hearing
No, filed by, my lord, this petitioner,
petitioner.
defendant number 1.
Yes, and that petition was allowed.
No, rejected, my lord. Rejected, my
Okay,
lord, saying that, my lord,
wa-
2 documents were,
1267 of 2025 was allowed. What was that petition?
well, that is for, my lord, calling of the original sale deed, which is in custody of the police.
So the trial court has observed that that document is you are not sure where that document is.
No, my lord, as by my,
You see, come to page number 41.
yes,
Last paragraph, record also reveals that
is may be in the custody. Because, my lord, after the death of the mother, my lord, plaintiff file a FIR, my lord, against the defendant number 2 and her husband and the defendant number 1. So in that case, my lord, the original sale deed and the death certificate were, my lord, seized by the police. So he stated in his petition, may be in the custody of the defendant number 2. So in that context, my lord, this statement is given. And another statement is regarding this sale deed, my lord. It is a specific statement is there because that is already seized by the police.
when Mr. Sinha, you say the death certificate which the defendant number 1
Hmm.
tried to call for is cancelled.
Now, my lord, as per my instruction, that is under challenge before the, my lord, authority. That may be, my lord, interfere, my lord, because that, as per my instruction, my lord, when this certificate was cancelled by the authority, my lord, fact is 2 certificates were issued. Now the certificate which is annexed by the plaintiff
No,
in
no,
their,
that is not the issue before this court.
my lord. Yes, regarding this certificate, my lord, which is, I have, my lord, want to call for.
Mm,
This is as per here, the observation that is cancelled.
mm.
So as per my instruction, that is put under challenge. And my lord, that may be interfere in the subsequent states. So my only prayer is that may be called for, my lord, because that is required for deciding the whole issue in this suit. That is the only limited prayer. If that is cancelled, my lord.
No, until and unless that finding is interfered with, how that document will help you?
No, my lord, this is the finding of the trial court that is cancelled.
Mm,
So that's why I have filed this petition. Regarding the cancellation, as per my instruction, my lord, that is already put under challenge by the defendant number 2.
mm.
My lord, my prayer is, if this petition is not allowed until, my lord, in this stage, subsequently, if that was interfered by the court and say that that cancellation is withdrawn or, my lord, withdrawn. In that case, my lord, I have to again call for that document, my lord. My only question is, let them call for that document, my lord. If any observation has come out in the subsequent, that will, my lord, taken care by the trial court.
Let notice go at this is this. Heard, Mr. Sena, learned counsel for the petition. Petition under Article 227 of the Constitution of India. The petitioner is selling the order dated 11/11/2025 passed by the learned civil judge junior division number 1 Nagaon, entitled suit number 83 of 2019. Is so be noted here that by in order dated 11/11/2025, the learned trial court has dismissed the petition number 1266 of 2025 filed by the petitioner, which indicate defendant number 1 under order 11 rule 12 of the CPC, entitled suit number 83 of 2019, to direct the defendant number 2 to produce the original death certificate of late Noor Nehar Begum for proper adjudication of the suit, was rejected. Produce the petition and the documents placed on record. Let notice be issued to the respondent, returnable in 4 weeks. Step by speed post and also by usual process, we can return today. List of 4 weeks. And considering the submission of Mr. Sena, learned counsel for the petitioner, and also the facts and circumstances on the record, further proceeding of title suit number 83 of 2019, pending before the Court of Learned Civil Judge Junior Division number 1 Nagaon, stands state till returnable date. List of the 4 weeks.
Obligement.
Item 40.
Wait, please, your worship. My lord, here in this case, my lord, I have committed some mistake in schedule, my lord. And that too in the schedule, what happened, my lord? It should be 1 katha, it should be 8 lesa, my lord. 8 lesa, but it is written as one katha.
It should be 1 katha 8 lesa.
No,
It is written
No,
as 18 lesa.
Mr.
my lord.
Sheikh,
My
you
lord.
see the case is pending at the stage of argument.
My lord, that is the thing, my lord. That is the point decided by the court below, my lord.
Mm,
With due respect to the court below, my lord. But thing is this, my lord. My lord, this due diligence.
mm,
Due diligence is the point.
mm.
But thing is this, my lord, inadvertently, that is not in our knowledge. That has not come to our knowledge. It should be, definitely. But suit has been filed, it is continued, and ultimately, my lord, at the time of
Let us go
preparation,
through the petition file before the trial.
preparation of the argument, my lord, that has come to the
No,
notice. and
where is the petition?
My lord. petition page. Petition page, my lord, 13.
30.
My lord, that is the title sheet, your petition, amendment petition. My lord, page 23.
23.
Page 23.
In which paragraph you have explained your due diligence?
My lord, to be fair before your lordship,
Hmm.
here also, my learned friend in court below, my lord, failed to explain in detail. Only it is
Then
said
what
that
to do?
inadvertently, it has not come. And my humble submission before your lordship, what in the petition we can say?
Hmm.
Because it is only inadvertent, my lord. Otherwise not. Because, my lord, it has come into the notice at the time of preparation of the argument.
No, in your petition, there is not a single line is stated in your petition.
Preparing the final
that effect.
argument, my lord, your lordship will see page 23,
Hmm.
para 2.
Hmm.
That while preparing for final arguments, the petitioner discovered minor clerical typographical error in plaint, which has occurred due to an inadvertent mistake. So, my only thing is this, my lord, inadvertent mistake, it is not come to the notice. My lord, now the question before your lordship is this: whether what due diligence will be on my part.
Hmm.
That is to be considered, because it is not within my knowledge. It is inadvertent
No.
only,
That cannot be the explanation.
my lord.
Due diligence not explained, petition dismiss. Next.
Number 41.
Oblige your lordship.
Wait, please, Madam. My lord, I'm preparing this present petition on being aggrieved by the order dated 26/2/2026, passed in money suit number 4/2022 by my lord. Whereby my right to cross-examine of the plaintiff witness has been closed, my lord. And the facts of the case is that he has once been examined, my lord. Subsequent to his examination, my lord, I have filed a petition for amendment of my written statement, which was allowed, my lord, and thereafter again I have filed an application for cross-examination of the PW, my lord, which was also allowed, my lord. And if I may take, my lord, to page number 32 first, my lord. The last 4 lines, my lord. Both the PWs to appear on the next date, fix so and so for further examination if required, and further cross-examination of PW 1 and 2 in respect of the amendment portion of the written statement as submitted in so and so. Thereafter, my lord, on 17th, my lord, the next page, 33, my lord. We have appeared before the court, my lord. Both the sides are represented. Learned counsel, plaintiff prayed for adjournment via petition number so and so, stated that he is not able to come due to illness. Seen, heard, prayer is allowed. Plaintiff side filed another petition, via petition number, stating that PW2 so and so has expired on 7/5/2021. They prayed to pass necessary order in this regard. Seen fixed for further examination and cross-examination of PW1 in respect of amendment portion of written statement as submitted on so and so. My lord, I being the defendant, my lord, I have been appearing, but my lord, the counsel did not appear, my lord. Or the witness did not appear, my lord, with all due respect. Then the order which I am impugned by, my lord, is at page number 38. My lord, before going into the order, I would like to state before my lord that this has resulted because my lord, the petitioner before this, before my lord, his mother was ill, my lord, and she was admitted in the name care hospital, and subsequently on the next day of passing of this order, she has left for heavenly abode. And in fact, the engaged counsel, my lord, her mother-in-law expired 2 days back, my lord. So there was a miscommunication, and the counsel which is represented before the court, my lord, he was not an engaged counsel, he was only on verbal, my lord. He was asked to appear before to represent only, my lord. May I read the order, my lord?
So further cross-examination of PW1 was dispensed with.
my lord.
So
That is
you
the
are
only
agree
document
with
I have.
this.
Aggrieved by that, I have come before the court.
But you see, on that day, that witness was present in the court,
Yes, my
but
lord.
you remain absent.
My lord, unfortunately, my lord, there was a miscommunication. In fact, my name reflects here, but I have not been communicated off the record, my lord. And
No,
further,
no,
my
you
lord, the
see,
counsel who was engaged there, my lord,
the finding of the learned trial court, this is a judicial order.
my lord, absolutely, my lord.
Hmm.
And my lord, the counsel engaged there, her mother-in-law also expired, my lord. I have, in fact, I have annexed the, my lord, that letter also of Sadhu, my lord. So there was a miscommunication. This person who has represented, my lord, Jitu Nath, my lord, in fact, the learned counsel, he was not even an engaged counsel there, my lord. So he could not communicate. That is the only difficulty, my lord. We have been present in the earlier dates, my lord. The PW was not present, my lord, on the date. And in fact, my lord will consider that the date was fixed for examination in chief as well as for cross-examination, my lord. So it was a communication gap also that it would be fixed for.
Mr. R. Sanswa, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 26/2/2026. Whether you have filed any application before the court below
No, my lord.
after this order?
No, my lord.
It is to be noted here that by the impugned order dated so and so, the learned trial court has dispensed with further cross-examination of PW1. On the ground that the PW1 on that day remained present in the court since 10:30 a.m. and the counsel or the petitioner remain absent. Mr. Sensual learned counsel for the petitioner submits that in fact there was a miscommunication between the counsel present in the court and between him, and for which he could not remain present in the court. However, to a pointed query of this court, Mr. Sensual submits that after the order being passed on 26/2/2026, dispensing with further cross-examination of PW1, he has not filed any application before the learned trial court to afford him an opportunity to further cross-examine the PW1. But in that view of the matter, this court is inclined to dispose of this petition by directing the petitioner to file an application before the learned trial court to afford him an opportunity to cross-examine the PW1. And on such petition being filed, the learned trial court shall consider the same in accordance with law. And also considering the fact that there was a miscommunication between the counsel present before the trial court on that day with the conducting counsel. In terms of this CRP's disposal, you file an application there
My lord. I'm
when
deeply
the next
obliged.
date is fixed,
7th of May, my lord.
7th of May, before on 7th of May.
I'm deeply obliged, my lord.
Again, for school,
May I please go? The Assam Spoon, my lord, the mail, which is a defunct organization, my lord, approach before the labor court for the purpose of claiming their, my lord, salaries and wages, etc. Now, pursuant to that proceeding, my the labor court, my lord, initiated the proceeding, out of which, my lord, a commissioner report was also prepared in regard to the payment, my lord.
So Somoria, you say here you have impleaded the presiding officer labor court as respondent number 1,
Yes,
and indisputably and admittedly, this presiding officer is a judicial officer.
yes, ma'am.
Are you entitled to implead him as a party?
My lord, in case such a situation, my lord, what happened that once, my lord, this order has been passed by the particular, my lord, officer, my lord, Now, question is that the power which has been exercised is within the domain of that, my lord.
And who will represent him in this court?
My lord,
Who will represent him in this court?
my lord, that will.
And
be
what
the-
relief you were
this is
seeking
all
against him?
Government advocate, my lord.
Government advocate.
Yes.
You say there is a decision of Supreme Court.
Yes, my
You
lord.
cannot implead judicial
Yeah,
officer as party in the
I have
proceeding.
gone through that, my lord. But question is that, my lord, since this is the order, my lord, where if lordship kindly see, lordship otherwise required, we can strike out. There is no problem, my lord. That is
No,
not.
that decision is not available right now with me.
Yes, my lord. Yes, I have gone through, my lord. That Supreme Court decision that we cannot employ as a my lord party resolution, but lordship will strike out. There is no problem, my lord. There is no. Now, lordship kindly come to the conclusion of one issue, my lord. My lord, there is a clear-cut direction from this honorable court in paragraph 14, my lord, page 25. Lordship, just have a look, my lord. Page 25, paragraph 14, my lord.
No, first we have to strike out the name of the.
Yes, ma'am. Absolutely, my lord, that lordship may.
You file amended cause title. We'll consider on
Madam.
Wednesday.
Well,
Heard, Mr. Somalia, learned counsel for the petition. This petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 9/2/2026 passed by the learned presiding officer, Labour Court, Gauhati, in Miss Case number 3 of 2020, no, 3 of 2008. It appears that Mr. Somalia, learned counsel for the petitioner, has impleaded the presiding officer, Labour Court, Gauhati, as respondent number 1. And indisputably and admittedly, he is a judicial officer. And in view of the decision of Honorable Supreme Court in the case of Savitri, what is the citation?
decision, my lord. Right now, I don't know, but my lord, I have gone through that officers should not be implemented as a party responsible, my lord. Lordship, I will place it, my lord, after some time.
Judicial officer, you cannot be impleaded as a party in a proceeding. And in that view of the matter, arraying of the presiding officer, Labour Court, as party in the proceeding is contrary to the finding of the Honorable Supreme Court in the decision of so and so, so and so. Accordingly, it is provided that the name of respondent number 1 is struck up from the array of this petition. When Mr. Somalia, learned counsel for the petitioner, shall file amended cause title within a period of on Wednesday,
My lord, within this week we will file.
within this week. List the matter on Monday then.
Okay. Item for orders, item number 18.
May please, my lord.
Mm.
My lord, here I seek to withdraw the appeal with the liberty to file afresh before the Waqf tribunal. Since, as per the recent judgment of the Honorable Apex Court, the same may not be maintainable. In an earlier CRP was as well, this Honorable Court was pleased to pass the same direction. I am just forwarding the lordship's permission and forward both the orders. Thank you.
This appeal relates to what property?
Waqf property, my lord.
You are for the appellant.
I'm for the appellant, my lord.
Who is appearing for the respondent?
My lord, Mr. R. Ali was appearing for the respondent.
Or like Sorry, RLA. Wait for some time.
19.
Non-address for the petition or on call, lays the matter after a week. In the event of subsequent non-representation of the petitioner, appropriate orders shall follow.
Item 20. This is my letter is office note regarding the substitution of the responsible fee. The flag, my flag mark is here. So, they have not done.
Lordship, we need some more time to file substitution.
Okay. Heard, miss, your name, please?
S. Ahmed on the behalf of R. Chaudhary.
Learned counsel appearing on behalf of Ms. R. Chaudhary, learned conducting counsel for the petitioner, and Mr. Nazar Bhuiya, learned counsel for the respondent number.
Respond number for except 3 my for others I am appearing. Respond number
For
1.
rest of the respondent, except respondent number 3. Learned counsel appearing on behalf of Ms. R. Chaudhary, learned conducting counsel for the petitioner, submits that the petitioner needs some more time to file impleadment petition. Fair allowed to recessalize the matter after 2 weeks. After 2 weeks.
3 weeks, my lord, because I will be out of session. It comes up.
3 weeks.
Right.
Of license.
Items 21 and 22.
May I please the Lordship. Lordship, in this case, Lordship, newly implemented Lordship, containment number 4 and 5. Lordship, as per the office note, Lordship, 4 is appeared and 5, Lordship, though in the office note is not office date order dated 8/4, but on 8/4, Lordship, the 5 already appeared, that is showing in this cost list as well as Lordship in the CIs. So, Lordship, service has been completed, Lordship.
Who is appearing for 4?
Lawsuit for 4. Appearing for 5 for 4. Appearing for
1, 2, and 3.
4 is P Sharma, Lordship. It's showing cost list, it's showing P Sharma.
P. Sharma.
Yes, Lord.
Whether P. Sharma is available in the court.
Lordship, in the Ukalatnam also is there, Lordship. I have said.
The name has names.
Yes, yes. P Sharma.
Heard, Mr. Hawk, learned counsel for the petitioner.
My affidavit is already filed. I have already filed by.
Fine.
Lordship, earlier operations, Lordship, pursuant to their affidavit, thereafter, Lordship, the court is issuing the notice, the hyper committee chairperson and other members, Lordship.
And also heard Mr. Kosik, learned counsel for the respondent container number 1, 2, and 3. Mr. Soliha for
respondent number 5.
respondent number 5. None appears for the respondent number 4. Though when Mr. P. Sharma, learned counsel, file Ukalatnama on his behalf. It is submitted at the bar. You want to file affidavit?
I think my affidavit will suffice. Right?
Suffice. Okay.
Because I was the member secretary of the hyper committee.
Mr. Kosik submits that there is no requirement of filing a fresh affidavit in this matter. And as such, the matter may be listed for hearing.
I think the response number 4, affidavit would be required because he was the chairman, my lord.
Lordship, in the meantime, I will bring on the record of respondent number 5 also. I'll also file the affidavit on behalf of respondent number 5.
However, Mr. Soliha, learned counsel for the contender number 5, submits that he may be granted some time to file the affidavit. Fair allowed. No, Mr. Kosik, you see,
Madam.
one counsel has filed ukalatnama on his behalf.
Yes.
So we cannot compel to remain him present in the court. If even after filing of the ukalatnama, he remain absent in the court, we will proceed as per the
I'll try to inform.
list after
Lordship,
third date.
Lord, 1 week, Lordship,
13th May.
13, Lordship. Highly obliged, Lordship.
Item 24. This matter has been
Lordship,
only coming in order. In fact, what happened? I'm for the plaintiff, my lord, there are concurrent fighting in my favor, landlord tenant case here. Now, we filed a caveat. There is office notice says by mistake, they have not placed the case. And the matter was, notice was issued and interim order was passed in our absence, an expert. So we last occasion said, since it is the matter, because we have a decree by both the courts below, the concurrent finding. And there is a bona fide requirement, the man is suffering. So well, the court has fixed the matter, but again, it has come for order with a note that the notice on the respondent number 226, 229 is not served, but in fact, we file a case, there is there is a mistake.
So you are representing all the
All the respondents.
Okay, okay,
So since it has come for orders,
okay, okay,
Lordship, there's an urgency in the matter, great urgency.
okay.
Lordship will fix
Heard,
it.
Miss,
as Tori Lordship.
learned counsel for the petitioner. Then Mr. S. Roy, learned senior counsel assisted by Mr. E. Goswami, learned counsel for the respondent. Mr. Roy has pointed it out that in this matter service has been completed and the matter may be listed for admission hearing. Accordingly, it is provided
On
that
eight-
recess and list the
6th or
matter
8th,
for
6th or 8th,
admission hearing on
6th or 8th, 6th. 6th. Item 25.
this was in our.
My Lordship, the service has been completed. The matter may be listed for hearing in due course.
Heard, Miss, your name, please.
Tejas, appearing on behalf of SK Talukdar.
Who is your senior?
SK Talukdar.
Learned counsel appearing on behalf of Mr. S.K. Talukdar, learned conducting counsel for the appellant. Referring to the office note dated. No, referring to the order dated 26/3 of 2026. Of the laws in my court, learned counsel for the appellant submits that in this matter service has been completed and the record of trial courts as well as first appellate court have also been received and as such the matter may be listed for hearing. Accordingly, it is provided that recess shall list the matter for hearing in usual courts.
Item 26.
That is your lordship. We have taken steps, lordship.
Third, Miss,
Same sake, your lordship.
learned counsel for the petitioner. Office note dated 23rd/4, 2026 indicates that service in respect of respondent number 1 stands completed, but the respondent number 1 remain unrepresented today. The said office note also indicates that neither AD card nor unserved notice issued to the respondent number 2 received till date. List the matter after 2 weeks, awaiting service report upon respondent number 2.
Made please, Your Worship. Like this, IA number 2974 was filed against the order passed by Your Lordship on 8/8/2025 below, where Your Lordship was pleased to grant this petitioner to withdraw this CRP IO 16 of 2025 to file appropriate application before the appropriate court, my lord. I have annexed that order. Now, Lordship, after that, this petitioner has found that as because there is no decree against the impugned order, which was my lord's annexed in the CRP IO 16 of 2025, that was under Order 9 Rule 7 CPC. There is no decree because there are two defendants, my lord. One, the case is still pending. There is no decree against this defendant number 1. What happened, my lord? Your lordship was on that day, my lord, opined that, my lord, there is no such petition lies under 227, reduced section 151 CPC against an order under Order 7 rule, Order 9 Rule 7, my lord. Therefore, my lord, this petitioner, since the suit was old, about 2 years old, my lord, and it is ex parte order. Therefore, my lord, petitioner advocate, my lord, paid for withdrawal of the suit, my lord, this case, my lord, CRP 2016, my lord, 16 of 2025. Now, lordship, why I have filed this IA, my lord, to restore this, my lord, CRP IO 16 of 2025, my lord, because the order, your lordship granted liberty to file any application. I have found that, my lord, there is no such provision to file any application because there cannot be any appeal against that order. Therefore, my lord, on the last occasion, I have, my lord, given two Supreme Court decisions under, my lord, the provision of this 151 of the CPC. Your lordship has enough power to restore this petition because, my lord, one order was, my lord, one judgment of Honorable Supreme Court 2006 3 SCC 699 was, my lord, read over on that day, where in paragraph 25, is it in the record, my lord? I have submitted already. 2006 3 SCC 699. Here, my lord, Honorable Supreme Court, that was, of course, Mr. Repetition. The aforesaid position was reiterated by the learned single judge of the High Court in its order dated 4/2005. Though the language of the used by him is not entirely convincing. However, the position was clarified by the learned judge in his subsequent order dated in which reference has been made to division bench decision of the Calcutta High Court in Rameshwar Sarkar, which in our view correctly explain the law with regard to the inherent power of the court to do justice between the parties. This is the formula. There is no doubt in our mind that in the absence of a specific provision of the Code of Civil Procedure providing for the filing of an application for recalling of an order permitting withdrawal of a suit, the provision of Section 151 of the Code of Civil Procedure can be resorted to in the interest of justice. The principle is well established that when the Civil Procedure Code is silent regarding a procedural aspect,
the inherent power of the court can come to its aid to act ex debito justice. For
Mr.
doing-
Goswami,
my lord, this is 24 paragraph. This is the judgment, my lord. And another
no,
judgment,
no,
my lord.
Mr. Goswami,
Lordship.
there is no doubt that this court has the power to restore that
Yes.
petition. But the question is whether that petition is maintainable or not. That was the issue on that day before this court. So there is one decision of the Supreme Court. We'll take it up at 2 o'clock today.
My lord, my lord. Regarding the point of whether it lies under order 7 rule, order 9 rule
Okay.
7.
Yes, yes.
Okay. Obvious.
May it please, Your Lordship.
Hmm.
Your Lordship, as per office note, the miscase 58 of 2025 is received, but it appears that the title suit number 22 of 2022 is not received, my lord. It will be required for proper adjudication. It may be called for, my lord.
So the scan copy of the record has been received.
Yes, my lord. The miscase number 2020, miscase number 50 of 2025 is received, my lord.
Yes.
But the main title suit of 2022 is not received, my lord.
That was not called for.
Yes, my lord. That was not entire case record was called for, my lord. But the only part has been received. Midge case has been received, my lord.
No, why an entire case record is necessary?
Because, my lord, in this petition number 1200 of 2025, my lord, it was prayed to amend the plaint, my lord. In the plaint is the title suit, my lord. Prayer for amending the title suit, my lord.
Mr. Chauhan, respondent, all the respondents,
Sole respondent.
sole respondent. So whether the record of title suit is required here?
Plaint is there,
No, certified copy of those documents can be produced here.
otherwise pleadings are there. The documents are not there.
Where?
Because
In the miss case.
documents submitted in the court below my lord not enough. There. My
Heard,
lord,
Mr.
the petitioner may file document, then my lord record will not be requested.
Okay, you furnish the certified copy of the plaintiffs and written statement.
That can also be done.
Yes. Heard, Mr. Your name, please.
Digital order.
Learned counsel for the petition and Mr. Sohan, learned counsel for the respondent. This matter service has been completed and the record of Ms. J case number 50 of 2025 has been received. Though the learned counsel for the petitioner submits that the record of title suit number 22 of 2022 has not been called for and that the same will be required in order to deal with the dispute in this petition. Yet, it is provided that the learned counsel for the petitioner shall furnish the certified copy of the plaintiff and written statement and other relevant documents filed before the learned trial court in title suit number 22 of 2022 before this court on next date. Rest is the matter for admission after 1 week,
1 week,
2 weeks, my lord.
2 weeks.
After
Okay,
My
after
lord,
2 weeks.
there is an interim order, my lord.
Interim order pass earlier shall continue.
And a date may be fixed, my lord.
in 20. 21.
Blessed.
May it please your lordship. Your lordship kindly see my lord order dated my lord 16/3, my lord. Today it is my lord for consideration of interim order, interim pair, my lord. Your lordship kindly see my lord order dated 16/3/2026, my lord. So fact of the case is this, my lord. There are 3 brothers, my lord. One of the brothers.
So the trial court has allowed the application.
My lord.
Allowed the application.
Allowed the appeal. That's why my lord revision before. Otherwise, there is a appeal, my lord. If it is rejected, then appeal lies. It order 43, your lordship kindly see that if the petition under order. This order, order 9 rule 13, if it is rejected, then my lord, appeal lies. There is a
If it is
specific.
allowed, then revision lies.
Then revision. That just because there is no appeal, that's why my lord revision. So that is the. So here in this case, my lord, your lordship kindly, there are 3 brothers, my lord. One of the brother filed an application for my lord mutation, my lord, and partition, my lord. That partition suit was, my lord, that was decreed in my favor, and my lord on compromise, my lord. On compromise, my lord, by giving a 3 equal share to all the 3 brothers, my lord. They are the ancestral property, my lord. So in that case, my lord, execution was not done, my lord. And my lord, when filed an execution case, my lord, after receiving the notice of the execution case, my lord, one of the brother came to the court, my lord. He says that I have not received notice, so that has to be set aside. So accordingly, it was set aside, my lord. In fact, my lord, notice was received, my lord. He has signed, my lord, and your lordship kindly see Annexure 3, my lord. Annexure 3, page 38, my lord. That is the report of the Jarika, Bisharpoti, 2026/7/2011 তাৰিখে notice নামত থকা ঠিকনা উক্ত notice নাম থকা লোকজনক লগ পাই notice দিয়াৰ পঢ়ি চাই সহি কৰি copy notice গ্ৰহণ কৰে. That was the report of the Jarika. Without even examining him, my lord, petition has been allowed. So that is a document of the court, my lord. Just because he says that I have not received notice, and my lord, petition was allowed. After 11 years, that too, my lord, without filing, I am not going to that person. I am not going to that, my lord. Even, my lord, this is the document of the court, my lord. But court should have, my lord, at least examine him, my lord.
Because he says that I went there and he has received the notice by putting his signature. So signature is there, my lord, yourself, Sanjeev Kakoti, my lord.
No, that's all right. Whether this document was taken note of by the learned trial court
No, my lord.
while passing the impugn order?
Passing the, my lord, then on different count, my lord, your lordship kindly says the signature is not my lord. How we can, my lord? Your lordship kindly see the order, my lord, of impugn order, my lord. Impugn order 4/12/2025, page 65, my lord. Both sides are represented. May I read it, my lord?
No, come to operative person.
My lord. No, that is not very long order, my lord. In me, my lord. On 2 count, my lord, I am filing this petition, my lord. After 12 years, my lord, they file a application, my lord, without giving any condonation petition. Not a single line regarding delay, my lord. Then there is no explanation at all. Number 2, my lord, this person, the notice was served, and notice was served, my lord, that without examining that person, my lord. Notice that petition was that ex parte order was being set aside, my lord. That regarding, my lord, notice, page 67, my lord, party portion, my lord. Page 67, my lord. Again, on a careful scrutiny of the case record at TS number, it appears that on service report of the summon, it was TS number dated so that is available in the case record. A said service report of the signature of the petitioner shown in letter Y. Letter Y in the word Kotaki, where the other documents signed by the petitioner as well as from the other plaintiff of the suit, the name and the signature of the petitioner and found to with the I in the word Kotaki and created prima facie impression regarding non-service of the summon and claimed by the petitioner. So that is the only finding on my lord regarding that examination of the my lord Jari Karak, my lord. So it is an official document, at least, my lord, without examining him, my lord, but petition should not have been, my lord, allowed. He may be, my lord, intentionally, my lord, he put his signature instead of Y, he said put in Y, my lord. But that has to be, my lord, Jari Karak has to be, because he says that I go there and a person was found there and he keep the notice by putting his signature. There's a very clear, my lord, document of 2011 document, my lord. Even your lordship kindly see they are in their petition.
At what is this the case is pending now?
My lord.
At what is this the case is pending now?
No, now, my lord, already the decree has been decree passed, which was passed in favor. In fact, it is favorable on all the petitioner, all the my lord brothers, my lord. Now, my lord, that is been set aside, my lord.
No, not the entire decree.
Entire decree, my lord.
No,
Your lord,
no.
that is the my lord. That is the another third ground, my lord. Your lordship kindly entire decree has been set aside, my lord. Which is also law does not permit, my lord. Your lordship kindly page 68, my lord. Even without hearing other orders, my lord. TS number showing last part of the order, my lord. May I read it, my lord? TS number 26, 2011 was portion of for the permanent injunction, and that decree was passed in favor of the partition of the ancestral property of the plaintiff and defendants. Thus, from the nature and decree, it appears that the said document cannot be set, decree cannot be set aside against the petitioner, Sri Sanjeev Kakoti alone. Hence, the decree dated so and so is hereby set aside against all the defendant and performer defendant.
Okay.
So, entire decree has been set aside.
But just before the before that paragraph, the trial court has observed that I found it proper and reasonable to set aside the judgment and decree again dated 38/8/2012
Against the Sanjeev Kakoti. That
Yes.
but last part is, my lord. Last part is against all, my lord. So, matter may be examined, my lord. Yeah.
No, that's all right. But the respondent entered appearance, so we can finalize here and discuss.
No,
on
my
the
lord,
matter.
your lordship kindly see, if your lordship, my lord, that suit is going on in court below, my lord, he will file a WS, my lord, you will take time, my lord. My learned friend appearing, my lord.
For the respondent number 1, lordship, we are appealing for that defendant number 1 in the suit, lordship. And presently we have filed a after setting aside the order,
Mm.
and now trial is going on. Lordship. Can I?
Mm.
Lordship, it was a suit for partition, but there were 5 brothers, Lordship.
Mm.
But the plaintiff, Sanjay Kakoti, he has not taken any initiative for partition of the suit. So it was very clear that there was no cause of action because they are the brothers, and no doubt all are having a stake on that property. And 14 losas of land along with the building should be shared of each of the brothers, Lordship. We do not have any dispute regarding that. But Lordship, the decree was passed keeping respondent number 1 in that, Lordship. Why I'm saying is, that time the suit was filed in 2011 and the decree was passed in 2012. It was an ex parte decree and it was a compromise decree among rest of the brothers. Rest 4 brothers. But in fact, Lordship, rest 4 brothers are not in possession of the suit level, Lordship. Only 2 are respondent number 1 and Sanjay Kakoti.
No, we are not concerned with the merit of that partition suit.
Right now,
We are concerned with the impugn order. You see, this annexer 3 at page number 38. This is a report of the process server. And it is stated that the notice was served upon the person concerned who put his signature. Whether word I or Y will make any difference.
If we consider the power of the court given by
No,
Section
you see,
73 of Evidence Act.
this process server was not examined by the trial court.
Yes, but it was very palpable error. And there are so many things which actually learned court builders very prudently passed this order, set aside the order, set aside the decree, my lord. Because Lordship, the 14th, if you kindly look into the, there are so many things that has been suppressed, Lordship. If you kindly look into the decree, Lordship, will find, Lordship, that 14 losas land, they have partitioned as 7 feet into 120 feet in each share.
No, we are not concerned with the merit of the decree and the
Executable
order passed by the trial court.
Yes,
We are concerned with only the impugn order.
yes, Lordship. Now,
So
while
you
talking
say
about-
whether in the light of this light of this report of the process server, the impugn order
is fine.
can be said to be legal
Or not. That is the question. Lordship, there was suppression regarding, maybe there was a collision between the process server and the plaintiff in that case, Lordship, because we have not received any. And Honorable Court has examined the signatures as per the power given by 72, Section 72, subsection 1 of BSA.
No, that power is there. But what is the procedure?
Court has examined it.
No, what is the procedure?
Court can examine of the full.
Court ought to have examined this process server.
Yes,
That is the first duty, man.
Who has given the report?
yes, Lordship. There is another point, Lordship. There is an admitted signature. There are so many admitted signatures of the respondent number 1, and that is the disputed signature. And court has compared the disputed signature with the all admitted signatures, and it was found by the Honorable Court that it was a forced signature.
In which
And-
part of the impugn order such observation was made?
Page 67, madam.
Decree is not executable, Lordship, because we are in possession of the suit.
No, that is not the subject matter of this petition.
Yes, Lordship. And all those things were brought before the learned court while before passing this order during submission, and court has taken into consideration all the facts and circumstances.
Okay, then we are staying the impugn order.
Case number 67. Sorry, sir.
We are staying the impugn order. Heard, Mr. T. Mohanto, learned counsel for the learned senior counsel, assisted by Mr. T. Gogoi, learned counsel for the petitioner, and Mr. Sharma for the respondent. Mr. Mohanto, learned counsel for the petitioner, has pointed out that in the order dated 16/3/2026, there is an observation that today the interim care of the petitioner will be considered. And accordingly, referring to the impugn order dated 4/12/2025, and also to the annexer number 3 at page number 38, the report of the process server, Mr. Mohanto, submits that the respondent herein has received the summon as per report of the process server dated 27/7/2011. And despite the said report available on the record, the learned trial court in Ms. case number 169 of 2025 has set aside the judgment and decree dated 30/8/2012, passed the title suit number 26 of 2011.
22. 26.
And the said order is illegal and arbitrary in view of the report of the process server, and as such, there is a requirement of staying the impugn order till disposal of the petition. Mr. Sharma, however, opposed the petition on the ground that the impugn order suffers from no infirmity or illegality requiring an interference of this court, as the learned trial court, after due observation in the impugn order, has set aside the judgment and decree dated 30/8/2012, and that the said decree is in fact inexecutable, and therefore he contended to dismiss the petition. The submission of learned counsel for both the parties needs further consideration. Further consideration at this stage. The impugn order dated so and so, passed by the learned trial court, stands state till disposal of this petition. And since service is completed in this matter, this is at least the matter for hearing, no, for admission hearing on fixed date.
18 to 8.
My lord.
Silence 22.
Oh, hello. Evening.
Please, Your Lordship, in office note 23, my lord, 23/4, that neither AD nor answer products 1 and 2, my lord, in respect of. The 3 is pro forma, my lord. You may wait 1 week or 2 weeks, my lord, it may come. Otherwise, my lord, interim order, my lord, would have considered, but not appeared yet.
No, notice is yet to be served upon respondent number 1 and 2.
1 and 2, my lord.
3 refused.
3 refuse.
Hmm.
1 and 2, neither ready nor answered. Let
You want to take fresh step?
May
Or will
the
await service
purpose
report?
has passed only we wait 2 weeks, my lord.
Okay. Heard Mr. Goswami, learned counsel for the petitioner. Office note dated 23rd/4/2026 indicates that Respondent number 3 refused to receive the notice. And accordingly, the same was returned with a report. In view of the aforementioned report, notice deemed to have been served upon respondent number 3. Said office note also indicates that neither ID card nor unserved notice issued to the respondent number 1 and 2 return till date. So leaves the matter after 2 weeks, awaiting service report upon respondent number 1 and 2.
33.
May I please your lordship? As per office note dated 23 April 2026, neither AD card nor unserved notice have returned till date with regard to respondent number 1 and
So
2.
when did you take step upon them?
Lordship?
When did you take step upon them?
Last date on the
Third, Mr. Your name, please.
JSIQ.
Learned counsel for the petitioner. Office note dated 23rd/4/2026 indicates that neither ID card nor unserved notice issued to the respondent number 1 to 9 returned till date. Place the matter after 2 weeks, awaiting service report upon respondent
Lordship,
number 1.
Interim may be given. Continue to this, may be given to the
Interim order passed by the order dated 28/3/2026 shall continue.
Okay.
34.
2 weeks.
My lord, file this review application, my lord, for review of the order passed by this honorable court, my lord. Page 71, my lord. Operative portion.
This I is for delay condonation.
Delay.
90 days delay.
Yes.
Let notice go and discuss. Heard Mr. S.K. Ghosh, learned counsel for the petitioner. This application under section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 90 days. In preferring review petition against the judgment and order dated 14/10/2025 passed by this court in MSC Appeal number 4 of 2016. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks.
125.
I'm for the applicant, file for early hearing. What has happened? The petitioners, the applicants are aged persons, and the applicant has blocked the path, so they cannot move. One of the premises also expired. So they're in the advanced stage. The main path was blocked by the. They have to one cannot go to his land, others have to go 500 meters away. There is a order in 19/3/2025. Both the properties are liberty file available for
Okay.
early hearing.
Any objection? No. Heard Mr. S.R. Gogoi, learned counsel for the petitioner. And also heard Mr. S. Sharma,
S. Sharma.
learned counsel for the respondent. This application is filed by the applicant for early hearing of RSA number 34 of 2023 on the ground that the appellants. You are for the appellants
I'm for the plaintiff respondent 1 to 4.
here.
Yeah,
In the
and
RSA.
in the RSA, and applicant in this I.
The respondents herein are old and aged person, and as such, there is a requirement of early hearing of the aforementioned early hearing and disposal of the RSA number 34 of 2023. The learned counsel for the respondent opposite party submits that he has no objection. In the event of allowing this interlocutory application, they are allowed. Accordingly, taking note of the submission of learned counsel for both the parties, this application stands allowed. This is a list of RSA number 34 of 2023 for hearing. When
The month of May.
suggested that
Oh, yes.
On 2nd June.
Must oblige.
36.
May it please, your lordship. Well, this I for delay of my lord 58 days. Listed for the first time.
revision petition against
My lord, against the my lord, dismissal of the review petition, my lord,
dismissal of review petition by
by the learned tribunal, my lord. Dhubri, MSCT Dhubri. My lord, what has happened, my lord? There was a award passed based on a fake policy, my lord. We had pleaded by filing a review because it was my lord, unearthed after passing of the judgment.
no, you have not contested the proceeding before
We
the
were, my
tribunal.
lord, we had contested, my lord. At
You have
that
not
point of
produced
time, from point of time, it was not ascertained, my lord, that it was a fake policy. Immediately after passing of the award, when the process was being undertaken to satisfy the award, then it was learned that it was a fake policy.
Okay, let notice go ahead. This is this.
My lord.
Heard Mr. Bhatra, learned counsel for the applicant. This application under section 5 of the Limitation Act is preferred by the applicant seeking continuation of delay of 58 days in preferring connected revision petition against the order dated 19/4/2024 passed by the learned motor MSCT Dhuburi, whereby the learned tribunal has rejected the petition number 1367 of 2018 filed by the petitioner and dismissed the review petition number 1366 of 2018. Let notice be issued to the respondent opposite party. Step be taken by speed post and also by usual process within a week from today, list after 4 weeks.
My lord, the review petition was numbered as Miss Case 06 of 2000. Miss Case 06 of 2018, my lord. Page 2, my lord.
Okay. Review petition number 1366/2018 within bracket Miss Case number 6 of 2018.
Obliged, my lord.
37.
Well, in 37, it's a regular, my lord, it's again a revision petition, my lord. The award is below 1 lakh. So, my lord, we have filed this revision.
Heard Mr. Bhatra, learned counsel for the applicant. This application under section 5 of the Limitation Act is prepared by the applicant for condonation of delay of 35 days in preparing connected revision petition challenging the impugned judgment and award dated 6/11/2025 passed by the learned member Motor Accident Claim Tribunal Nalbari in MSC case number 289 of 2018. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks.
Obliged, my lord.
38.
May it please, my lord. My lord, there is a delay in preferring the appeal of 110 days. The IA pertains to the delay, my lord.
110 days.
110 days.
Heard Mr. Chaudhary, learned counsel for the applicant. This application under Rule 3A of Order 41 of the Code of Civil Procedure is preferred by the applicant for condonation of delay of 110 days in preparing regular second appeal against the judgment and decree dated
The impugned judgment and decree is
22nd July 2024, passed in title appeal number 04 of 2018 by the learned civil judge senior division Barpeta. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by speed post and also by real process within a week from today.
There is another interlocutory application for stay of execution proceedings which came to the notice of the applicants later on. I understand there is a delay, my lord. I'll just please.
No, we'll consider that only after
True, my lord. I'll, if with your my lordship's due permission, I'll just place one judgment of the Bombay High Court and one of our High Court. Just states that in exceptional circumstances when
what exceptional circumstances
executions
is there in your
might
favor?
be, my lord, execution proceedings have been reinitiated rather. It was of the year 2018. We have recently come to know that a writ has been issued and it is fixed for report on 30th of this month. Till at least the appearance of the parties.
No, without condoning the delay, we cannot pass any order at this stage.
Very well.
46.
Kindly peruse your lordship last order, my lord. But it is a second appeal filed in the year 2014, my lord. 30 days delay. Dispute between brother and sister, my lord. But they are avoiding in spite of receiving the notice. Last order of the honorable court. His name is also shown. So delay may be condoned, my lord. Register direction may be given to register the registry, my lord, to second appeal, my lord.
No, in the order dated 28/1/2026,
Yeah.
there was a direction
Yes, my lord.
to take fresh step.
Already taken, my lord. But learned counsel who was conducting the case, he has also received it. That's why, my lord, I am placing the order, my lord. They are paragraph 2, kindly peruse your lordship. Paragraph 2 of the order. 2 and 3. 3 paragraph. Last order. I have
No, you first you tell me whether as per direction issued in this order,
yes, my lord.
at paragraph number 5, you have taken steps.
Yes, my lord, taken steps, but that is insufficient address because she has shifted from to different place, my lord. The respondent already in different area, my lord. And the learned counsel, he is not telling me the actual address also. He has appeared and received the copy of the amended petition also, my lord, but
No.
he is not appearing.
Mr. Das, you say there was a direction of this court to take step. You directly tell me whether you have taken step or not.
Taken steps, my lord. There is office note 23/4/26. Unserved notice received. Taken steps.
Then under which provision notice deemed to have been served upon them?
Because earlier learned counsel who was conducting the case, my lord, in this case also appeared, my lord. And in the order itself reflects, my lord, kindly peruse your lordship. Because, my lord, during the pendency of the case, sole respondent expired. Thereafter, I have filed, my lord, impleading petition, etc. All allowed, my lord. Thereafter, it has come. And when it was listed before this honorable court, my lord, passed order, my lord, to place the my lord, amended cost title, my lord. Already placed it. And copy served upon him, but he is avoiding because, my lord, I have to, his instruction is to compromise the case, my lord. But as I have, my lord, my client has refused to compromise the case. Therefore, again, he refused to appear, my lord. Otherwise, his okalatnama is there, my lord. Mr. Pushpa Das, my lord, and his name is also, my lord, shown in the cause list, my lord. Kindly peruse your lordship. The okalatnama filed by him.
No, then why there was a direction for issuance of the fresh notice?
Because, my lord, he is not appearing, my lord.
In which cause list his name is reflected?
In the cause list, today itself it is reflected. PP Das, Puspo Das. In order also it is discussed, my lord, regarding that. He has received it. Item 46 supplementary list.
Then why you have not pointed this out to the court on earlier occasion?
Earlier, it is pointed out. That is why in the order itself it is reflected. In spite of that, Honorable Court observed to take steps. Again, I have taken steps. But after taking steps, my lord, this office note has come again because she has left. All have been mentioned in the earlier.
No, in view of this order and the office note, we cannot proceed. Covered. Okay, we'll take it up at 2 o'clock. In
Yes,
the
my lord.
meantime, he will try to contract the council.
Yes, my lord.
May I please, your lordship, this is a transfer petition, my lord. And now they have filed a affidavit on 28th of March. They have served a copy to us. And according to, it is on record that they are participating in a different proceeding in the district of Karimganj. My lord, now presently it is Sri Bhumi. So we are claiming the transfer of the case, that divorce which was pending before the district judge Silchar, and we claimed to transfer it to the district judge Sri Bhumi. And they have admitted that they are participating in a different proceeding, that is criminal miscarriage, which was filed for maintenance under section 125. They have not participated in that proceeding. It was ex parte. Thereafter, they have filed a criminal revision petition before the district judge Sri Bhumi. It is on record, my lord.
So we have already filed our affidavit in opposition. But on last occasion, your lordship had directed the registry to take the same. But it was lying defective, my lord, before the registry. So today we have cured the defect, my lord. And it is shown to be filed today itself.
So, my lord, as
In
per
fact, on 23/2026, we have filed a affidavit, my lord, but it was lying defective. And there was no communication was made.
of course, they served the copy to us on that day, but according to the online, we have gone through it. It is just today only it is on record.
So it is placed on record? Is it placed on record?
No, my lord. Because it was lying defective. Today itself, we have cured the defect, and now it has been shown in the online.
And my lord,
that it has been
it is on record. My learned friend is there. Of course, he can say that whether it is wrong or right, because he has filed a criminal revision petition.
No, the affidavit is not before this court. Let it be on some other day.
Maybe on my lord, short date, maybe.
Short date.
Heard, Mr.
PK Das, my lord.
Learned counsel for the petitioner, and Mr.
He does.
Learned counsel for the respondent. Mr. Das submits that the respondent herein has filed the affidavit in opposition, but the same is not placed on record. Accordingly, dismissal is the matter on next week. And take the affidavit filed by the respondent with this record.
48. My lord, there is an interim order. Interim order was there.
Interim order passed earlier, Selvan.
May I please, your lordship? As per office note dated 16/3, lordship, probably my learned friend is appearing for the respondent number 1 and 2. With regard to other respondent, service is not complete. The service is awaited for respondent number 3 and 4, lordship.
Other respondent, one is her husband with whom she is living now. And another respondent is her father, residing in the distance of about 300 meters. How they will serve, I don't know. They have taken a stay order, lordship. This is simply a visiting order of my granddaughter.
No, you will file your affidavit. In order matters, in the orders you are arguing with regard to this merit of the case.
Because the other two respondents, one is her husband. which
No,
was
these are all
changed.
these are all pro forma respondents. I'm just mentioning about the orders. I'm not saying that these steps or that step to be taken.
Joint
Maybe.
objection proceed there. Before trial court, they have filed.
This is
a
the
joint
procedural part. This is the procedural part. That is the reason why, because all are made party in the main proceeding. That's why these parties are there in these. And we have taken steps upon the respondents. Now the order sheet is the order as reflected in the order sheet.
They have signed, they have submitted the written objection jointly.
I have not completed my submission. I may press for not taking steps for striking out the name of the parties. I have not.
3 and 4 are not required.
Not required, Lordship, because this is a formal party in the means of proceeding. That's why they were made parties in this case. And I have
Part
taken
Mr.
steps.
S.P. Chaudhary, learned counsel for the petitioner. Mr. Potter for the respondent. Office note dated 16/3/2026 indicates that neither edit card nor unserved notice issued to the respondent number 3 and 4 received back by the section till date. Mr. Chaudhary, however, submits that respondent number 3 and 4
Maybe struck of Lordship.
are the performer respondent. Performer respondent in the title suit number.
Miss Guardianship case number 3 of
in the
2022.
Guardianship case number 03 of
2022.
And their name may be struck off from the array of this petition. Accordingly, taking note of the submission of Mr. Chaudhary, learned counsel for the petitioner, the name of respondent number 3 and 4 stands struck off from the array of this petition at the cost and risks of the petitioner. Since service upon respondent number 1 and 2 have already been completed and Mr. Potter entered appearance on their behalf, this is at least the matter for admission on
The short date mechanism. February
For
15.
15th.
Alright.
The interim order is there, Lordship. That will be accepted.
interim order pass earlier, sir. Continue.
Alright.
For admission, the number 7, part B.
Mr. Dotto, you say on 6th of March
Okay.
2026, you have submitted that the matter is being examined.
Yes, Lordship.
So since then you were examining the matter till date.
Lordship. What happened, what as per instruction Lordship submitting. Now Lordship, the
teachers was initially appointed from 82 was initially mobilized service in ME school. Thereafter the school got amalgamated with the high school. Now that ME school fall under elementary education. So the service rendered by petitioner under the director of elementary education there was very big. As per instruction lordship, they thought sometime that on receiving the instruction or report from the elementary education, director of elementary education, the government will finalize it. This is my stand.
No. When you are going to receive that instruction from the elementary education department?
Last but one paragraph, it is written that it is assured upon receipt of the report of director of elementary education, department of.
No. Is it your stand that you are not receiving the same till the last part of this year and you will not attend this matter? Hmm? Whether director elementary education is a party here?
Yes, madam.
Party. Who is appearing for the director elementary education?
Yes, madam, number 5. 2 and 5.
No, director elementary education is not a party.
District elementary education himself was the director, not the. No, the director.
No, my lord.
But district elementary.
My lord, here it is, my lord, I have claiming my pension, my lord, because there is a honorable court order which we are entitled for. We are drop teacher, my lord. We are entitled for the pensionary benefits, my lord. Yeah, I have annexed this order, my lord. On the basis of that, he prior to his retirement, he approached before this honorable court for his pensionary benefits, my lord, under this order, in terms of the order, my lord. And when he has retired from the service, my lord, he is from the director of secondary education. But if your lordship allow me, I will implement the elementary education. Otherwise, entitlement is there, my lord.
Then what report is required from the director elementary education?
And 2 to 3 questions,
Mr. Datta? Heard Mr. I. Alam, learned counsel for the petitioner, Mr. P.P. Datta, learned standing counsel for the secondary education department. Mr. Datta has produced one letter issued by the Joint Secretary to the Waqf of Assam Department of School Education dated 27/4/2026. And on the basis of the said letter, Datta submits that for consideration of the case of the petitioner, inputs from the Directorate of Elementary Education is required and the same is being awaited. And he pressed for listing the matter after
4 weeks. At least 4 weeks.
4 weeks. After 4 weeks. In view of the stand taken by the Directorate of Secondary Education, this court deem it fit and proper to implead the Director of Elementary Education as respondent number 8 in this proceeding. Accordingly, it is provided that the Director Elementary Education be impleaded as respondent number 8 in this proceeding, and Mr. Alam, learned counsel for the petitioner, shall take step for effecting service of notice upon the learned standing counsel for the elementary education, Director Elementary Education Department, during the course of the day.
Lordship amended.
I will also provide the.
In the meantime, Mr. Alam shall file amended cost title in this petition. The document, the letter produced before the court shall be marked as Annexure A and be tagged with the record. List after 4 weeks.
My lord, date may kindly fix me.
Cover.
After 4 weeks, my lord.
Take a date from him. Take a date. Hmm. Item number 12.
From 2:15 PM, bar council counting a lot. I'm an official agent there. Can it be taken now, your lordship?
Taken?
Now, your lordship. Just for the affidavit. 112. No, because it will be break now.
Item number 12. The other side is present today.
Yes, your lordship. Yes, sir.
I'm your lordship. Lordship, in this matter, Lordship, we have filed one additional affidavit. It was on record and it was filed on 1/4. But as the respondents counsel was not available, so it was recorded on 24. And on the last occasion, the other side said that no copy has been served on her. Now, Lordship, before this court, I want to give the copy of the additional affidavit. And Lordship, there is a point to be decided by this honorable court whether the interim maintenance given to the child and the mother by the trial court is reasonable or not in this matter, Lordship. And through additional affidavit, we have brought on record the present educational expenses of the minor child.
No, you say learned counsel for the respondent. Ms. Chaudhary, learned counsel for the petitioner, has served the copy of the affidavit to Ms. P. Das, learned counsel for the respondent. Before this court today, Ms. Das submits that she will file one rejoinder affidavit and she writes for granting her some time, pair allowed, list the matter.
Lordship, a short date because Lordship, interim maintenance has been
3 weeks time, my lordship. He said Itanagar. I will have to take instructions from him. I'm unable to get communicated with him over the telephone. That's why I require some time, my lordship.
Lordship, I have objection on
Okay,
this.
2
Lordship.
weeks. 2 weeks.
A date may be fixed, Lordship.
Okay. 13 from
For final hearing, Lordship. Because, Lordship, this affidavit we failed to serve because she is not available. On 1/4 we have filed. On 24, on 20 April, we filed it.
Okay, okay. On next date, we will consider it.
13/5. Obliged, Lordship.
May it please your lordship, my lord, before lordship, just permit me, item number 28, it will require some time, my lord, to go through certain case laws, my lord.
Okay. On the prayer being made by Mr. Goswami, learned counsel for the petitioner, the matter is then adjourned to be listed after 1 week.
Yes, okay. But both sides are present. Both.
Okay.
I have
Obliged.
more prayer, so item number 44 was there. And some other assignment was there by contradiction.
24.
44.
44.
But possible next week, Lordship.
Order is passed already.
No, Lordship. 44.
Okay.
Hearing on 41 petitions.
Okay. On the prayer being made by Mr. Kolita, learned counsel for the petitioner, the matter is then adjourned to be listed after 1 week.
What's the petition then of the possible?
13 May. Yes. Mr. Son,
May it please, Lordship.
Yes.
My lord, this is an application under section 114 of the CPC.
Yes.
With section 151 and order Roman 43 of the CPC. My lord, praying for the review of the order dated 19/3/2026 passed in WPC number 352/2025 passed by
Mr. Son,
my
on
lord.
that day, that order was passed in presence of both the parties.
Yes, sir. Yes, my lord.
So, how the now why this order is required to be no, is to be reviewed?
My lord, because my lord, the land in question is
Yes.
my lord, my lord, the petitioners all also involved in the area, my lord. So without the my lord, prior notice, that order was sorry, my lord, it was compromised before the deputy commissioner, and accordingly, my lord, it was placed before the this honor court, my lord. So the petitioners are totally affected because of the my lord, order passed by this honor court, my lord, because the land in
No, on that day, the petitioners herein remain present in the court through their counsel.
my lord, they were present, but here in the question, the petition, my lord, the petitioners' names were not impleaded by the opposite parties.
Okay.
So without impleading, my lord, it will be difficult to, my lord, get the relief from the deputy commissioner. My lord, once already that matter has been solved.
No, Mr. Son, you see, the petitioners herein, they are not the parties in the WPC number 352 of 2025 and
My lord.
247 of 2025.
My lord.
Now the question is, yes, Mr. Tada?
My lord, before I answer my lord's query that has fallen from the bench, my lord will kindly come to the synopsis of this review petition, which is something very objectionable, my lord. And this kind of petitions should be dismissed in limine with heavy cost, my lord. My lord, see, this review petition has been filed, if my lord has it.
Yes.
This review petition has been filed under section 114, read with section 151 and order 47 of Code of Civil Procedure 1908, praying for review of order dated 19/3/2026 in so and so passed by this honorable court, so and so, Itanagar, in connection with the land compensation matter on the basis of submission made by Advocate Mr. T. Garam and Mr. T. T. Tara respectively, without impleading the petitioners as necessary party, and surreptitiously, my lord, kindly mark this word, my lord, surreptitiously misled this honorable court as a matter being settled amicably between the parties, as a result of which the present petitioners are being affected. My lord, kindly appreciate, on the instructions of a counsel or on the instructions of the client, if the counsel appears, make a submission before the honorable court, the learned counsels cannot be attributed of playing fraud, my lord. I want this particular, my lord, paragraph to be expunged by this honorable court before my lord enters into the merit of this case, my lord. It's very painful to see, my lord. It's very painful to see, my lord. Even, my lord, kindly see, my lord, kindly see this. What is the legal implications in this, my lord? Therefore, my lord, I will pray for a suo motu cognizance and register a case for criminal contempt of the court under section 11 and 12 of the Contempt of Courts Act 1971, my lord, and initiating proceedings for perjury under the Bharatiya Nagarik Suraksha Sanhita 2023, my lord. For the reasons that, my lord, the petitioners have made a statement in paragraph 5. My lord will kindly flip down to paragraph 5, page 14 of the review petition, my lord.
Yes.
My lord, kindly come to page 15 straight. The same thing has been stated here in this, a categorical amendment has been made here, my lord. Kindly see, my lord, page 15, 19/3/2026 by the learned advocate Mr. T. Garam on behalf of the petitioner and Mr. T. Tara, learned counsel for the respondent number 7. It is pertinent to mention here in that the petitioner counsel, without obtaining certified copy from the registry of the court, have just printed out the order copy from the website and later on submitted said order copy to Deputy Commissioner as well as ADC Dambuk without submitting any compromise letter. There is no record of. My lord, kindly see, the petitioner was under oath under section 3 of the Oath Act, my lord. How can he make such kind of a personal aspersion against the counsel who has represented the client on instructions, my lord? This is something, my lord, I feel offended, my lord. For a moment, if my lord allow me to read what is section 3 of the Oath Act says, my lord. All courts and persons having by law or consent of parties authority to receive evidence have power to administer by themselves or by an officer empowered by them in this behalf, oaths and affirmation in discharge of duties are imposed or in exercise of the power conferred upon them by the law. Now, my lord, kindly see, by making a demonstratively false statement regarding the web printout versus the certified copy, we have submitted the certified copy, my lord, not the web copy, my lord. So this is something very serious, my lord. Kindly see, this has defeated by means of false evidence, my lord, before this court. Providing false evidence regarding court record is a direct violation of section 227 of the BNS, my lord. Triable, the procedure in section 215 of the BNSS and the contempt of the court, my lord. Well, this is something very serious, my lord. For the reasons that, my lord, we as a council under Advocate Act, subject to the section 35 of the Advocate Act, unless we don't commit any misconduct, my lord, no action can be attributed on us individually, my lord. My lord, kindly see, what I'm submitting is, my lord, under Advocate Act, we functions with full of immunity, my lord, of Advocates Act. Advocates Act acting on client's instruction, my lord. Now here, my lord, the petitioner's attack on learned counsel is a reckless attempt to intimidate the bar, my lord. This is not the simply seater that I am raising, my lord. Kindly see, my lord, the law is well settled. An advocate is an officer of the court, my lord. If a submission is made based on instruction, he cannot be accused of playing a fraud on the court or misleading the court merely because a third party disagrees with the outcome, my lord. This is something what, my lord, I will respectfully pray before this honorable court. Kindly register a suo motu criminal contempt against the petitioner, my lord. This is not, because by a stage of imagination also, such kind of petitioners, litigants should not be allowed to waste the precious judicial time, my lord. Second aspect, my lord, the second limb of my submission is, my lord, the locus standi of the stranger. The doctrine that the stranger doctrine, my lord, comes in, my lord. Now, my lord, kindly see, the petitioners are resident of Mayu to Blaze, Roing, my lord. Whereas the acquired land which the review petitioner is claiming is 68.40 hectare, starting from ADC, my lord, more to Mithun Gate at New Apali for construction of right bank approach road That is, my lord, will find at Annexure 6, my lord.
Hmm.
And also in page number 90, my lord. It's
Mr.
categorically
Tara,
My lord.
you see, today let notice go to the parties.
No, my lord, this should be dismissed, my lord. This should be dismissed because law is well settled, my lord. A stranger cannot come unless there is a demonstrably material facts before this honorable court, my lord.
Hmm. Okay, on
And there is
appearance
no
of
material
the appearance of all the parties, we will consider your pair. Today let notice go.
May I please, your lordship? Lordship,
Okay.
Lordship. Lordship,
Yes,
I'm
so what
appearing on
happened?
yes, lordship. I'm appearing on behalf of respondent number 123, lordship. That is
Hmm.
WPC 352 of 2025, lordship.
Hmm.
Lordship, what happened, lordship, on 23/2026, lordship, when
Hmm.
this matter came up before your lordship
Hmm.
for consideration, lordship, there was a mutual settlement has been settled between the parties, lordship.
Hmm.
And accordingly, without going into the merit of the matters, lordship,
Hmm.
your lordship has disposed the matter with the direction to the deputy commissioner. Consider the prayer which has been made by the parties within the period of 10 days, lordship.
Hmm.
Now, lordship, interestingly, this review petition has been filed by the petitioner, lordship, who is the third party, lordship.
Hmm.
Now, for the clarity, lordship may kindly come to the page number 26, lordship, of the review petition.
Hmm. Hmm.
Page number 26, lordship, the second paragraph, your lordship will find, whereas, if this is not legible, lordship, the type copy, lordship will find it page number.
No, it is legible, okay.
Lordship, whereas the executive director, NSPC rowing white letter dated so and so, has requested for expedite the process of land acquisition for a measuring our 17.62 hectare on the right bank for the construction of dam structure, lordship. 17.62 hectare, lordship,
Hmm.
wherein the party has approached the honorable court, lordship, and this honorable court on 23/2026, lordship, has disposed both the rate petition on the basis of the settlement arrived by the parties, lordship.
Hmm.
Specifically for the 17.62 hectare, lordship.
Hmm.
But inadvertently, lordship, in the order, lordship will find
Hmm.
that the order of the honorable court, that is page number 79, lordship.
Hmm. Yes.
Page number 79, your lordship will find the operative paragraph, lordship will find fourth paragraph, lordship.
Hmm.
It is further submitted. Lordship has filed.
Hmm.
It is further submitted at the bar that the parties are not willing to pursue these two writ petition as such. The same may be closed by directing the deputy commissioner rowing Lower Dibang Valley to dispose of the joint application filed by the parties before him in respect of plot of land measuring 17.62 hectare out of 66.678 hectare, lordship.
Hmm.
So, lordship, there are two acquisition process has been taken place, lordship.
Hmm.
One is for 17.62 hectare and another is for 68.88 hectare, lordship.
Hmm.
Now the petitioner who has filed this review petition, lordship, he is only concerned with the 68.88 hectare, lordship, which is a dispute between the several people, more than 7 people's there is dispute going on, lordship.
Hmm.
To that respect, lordship, the title suit has been also filed before the London Trial Court, lordship. Now, our concern is that, lordship, only 17.62 hectare, lordship. There is the legitimate owner is WPC number, wherein the parties which has been settled by among themselves, they are the legitimate parties, lordship.
Hmm.
Now, if your lordship review only this particular order, I think the grievances of the petitioner may be gone, lordship. To my humble understanding, lordship. If this order is modified only in respect of 17.62 hectare, lordship, instead of 68.88 hectare, lordship, there will be no dispute between the parties.
No, this is out of 66.678 hectare.
Lordship.
And that was the submission made by Mr. Tara on that day.
Yes, lordship. Inadvertently, lordship. That was inadvertently happened, lordship, before your lordship. Lordship, there is a two notification, lordship may kindly see.
Hmm.
This will clear everything, lordship. The lordship will find, lordship, this is the letter submitted by the executive director, lordship, NHPC, lordship. The release of compensation against of 17.62 land on the right bank of the construction of and so Dibang multi-purpose project lordship. Now another lordship will find the second page lordship. The release of compensation against acquisition of 68.88 hectare land on right bank for the construction so. Two acquisition process has been taken place, lordship. Now the petitioner who has approached this honorable court by way of this review petition, lordship, is only concerned with the second one, lordship. 68.88 hectare, lordship.
No, the question is whether they were the party in the rate proceeding.
No, lordship.
No.
Mm.
No.
So far as the lordship, the maintainability is concerned, lordship.
Mm.
I'm not on the maintainability of the review petition, lordship, but there is a slight confusion in the order passed by your lordship, lordship. Instead of
No, confusion means that this order was passed not on the merit of the petitions. It was passed on the submission made by the council for both the parties.
correct, lordship.
Then
So there was a
Agreed.
some
Submission was
there was some mistake has been came from the council side also, lordship. Instead of mentioning the 17.62 hectare, lordship, it has been reflected out of 66.678 hectare, lordship. Now, if you lordship will review only this portion, lordship, I think the grievances of the petitioner will be go, lordship. Because, lordship, the 17.62 hectare, where is the legitimate owner is the both the writ petitioner, lordship, who has earlier approached your lordship by way of writ petition, lordship. Now, this review petitioner, lordship, review petitioner is only concerned with the second proceeding of second acquisition process, that is 68.88 hectare, lordship.
no, in that second acquisition proceeding, no order was passed.
Yes, lordship. But the lordship, there since the even the deputy commissioner, the deputy commissioner, lordship, even after filing of the certified copy of the order passed by this honorable court, lordship, the deputy commissioner is confused that whether because if that order is read, lordship, that then it will cover also 68.88 hectare, lordship.
No, never. Out of
Lordship.
Out of.
Instead
That was
of
the submission made by Mr. Tara on that day.
correct, lordship. That is the mistake has been also committed from our side also, lordship. Because of this, lordship, there is a confusion, lordship. Otherwise, lordship, to the merit of the case, lordship, this review petition itself is not maintainable, lordship. Since the proceeding was going on before this honorable court from the last 5 months, lordship, and the notice has been issued to the deputy commissioner, pleadings has been exchanged, lordship, records has been called from the deputy commissioner. The review petitioner, if they are at all agree at that relevant point of time, they could have approached by way of implement themselves before the proceeding, lordship.
Yes, Mr. Tara,
My lord.
this observation was made on the basis of submission made by you.
Correct, my lord. There is one thing that has missed out with me, which I respectfully agree with my younger colleague who is physically appearing before lordship.
Yes.
That it was out of purview of that was the word I used, lord. Out of purview of the 768.40 hectare, lord, that I used the word. And after
No, Mr. Tara, you say whether presence of that word will make any sense.
my lord, that will clarify everything. That will clarify everything. Because in the second second acquisition proceedings, he is interested in 68.4080 hectares.
Yes.
Which Sonsari is also agreeing to that. In the second proceedings, my lord. This is in respect of the first acquisition. If that is the case, be so, my lord, can kindly close this.
Yes, lord.
Okay.
My lord, just one clarification, my lord.
Yes.
As my learned senior has fervently accused against the petitioner, which I, my lord, respectfully do not agree with the submissions. Number one is that, my lord, as per the period annexure 3, page 79. This is this is not a certified copy. because this was issued by the deputy commissioner to the petitioners. 79, my lord, 79 to 82. So there is no any, my lord, seal and signature, number one. So the petitioners has not done any crime against the, my lord, Lanet
No, no,
Council.
Mr. Son, you see, this order was downloaded from the website of the High Court.
Yes, my lord.
Then,
And secondly, my lord, QR code.
There is a QR code, my lord.
yes,
QR code, there is a QR code in the order itself. And my lord, this can be proved well if I give a certificate under section 63 of the Evidence Act.
So secondly, my lord.
But this kind of, my lord, casting aspersion on the council is not a healthy thing.
yes,
Still, I remember, my lord, in 2016, when I was Additional Advocate General during President rule, one of my senior colleague came out with an affidavit in the matter where I did not appear even, and subsequently that was expunged by then His Lordship R.K. Fukan. But this kind of thing, my lord, I will request her also not to do this. Because casting aspersion on your friend is casting yourself only, my lord.
My lord, this is in the instruction of the, my lord, petitioners, not by the, my lord, council, individual, my lord.
They fine, my
It
lord,
should
then
not be
kindly,
taken as a
my lord, kindly
individual.
initiate so moto contempt petition then.
Uh,
Kindly initiate. Let
So-
him prove. And my younger counsel, Mr. Garam, is there before Lordship. And we have submitted the certified copy
okay,
from where he
okay.
has created these
Let us,
documents.
Mr. Tara, let us do one thing. Let notice go at
Yes,
this
sir.
stage. And in the meantime, Mr. Son shall file amended petition, deleting the aspersion portion upon the council for the parties.
That's
We'll
fine. That,
hear the matter on next date. Since both the parties are present before the court, no formal notice is required to be issued. Heard Mr. T. Son, learned counsel for the petitioner. Mr. T. T. Tara, learned counsel for the respondent number.
my lord, luckily senior counsel, my lord.
Senior counsel, yes.
Yes, I am assisted by Mr. K.
Senior
Appa.
counsel assisted by Mr. Learned
K. Appa.
counsel for the respondent number.
My lord, this 9, 10.
Respondent number 9 and 10.
9 and 10.
9 and 10. And Mr. T. Goram for respondent number
1, 2, 3, lords.
1, 2, 3.
In WPC
1, 2, 3. This revision, no, this petition under section 114 CPC reduced order 47 rule 1 of the Code of Civil Procedure is directed against the order dated 19/3/2026 passed by this court in WPC number 352 of 2025 and WPC number 247 of 2025. It is to be noted here that by impugn order dated by order dated so and so, both the writ petitions were disposed of on the basis of the submission advanced by learned counsel for both the parties. Peruse the petition and the documents placed on record. Let notice be issued to the respondents. Returnable on. Who is representing the other respondents?
all the respondents are present, I think, also.
Okay.
Arich Nawam, learned additional.
My lord, I am there,
Mr.
my lord.
Navam, you are for?
My lord, I am for respond number 4 to 8.
4 to
4
8.
to 8.
Okay.
Correct, my lord. But
So suggested that on which we can fix the matter for final disposal.
my lord, may I just submit, my lord? My
Yes.
lord, in this review petition, so much of defects are there. See, the course title also, my lord, is defective, my lord. So what I can suggest,
my lord, Mr. Timestone can withdraw this review petition. He can file a fresh, my lord, expunging all the personal allegation and other things. My lord, let him, my lord, file as per the format, my lord. See the, my lord, course title, my lord. The course list given by the registry is, my lord.
Now, okay,
Government is not
Mr.
there.
Nabam, I am issuing direction to the counsel for the petitioner to file amended petition.
Not only paragraph, my lord, personal attack that has to be expunged, my lord. Even the
That is
course
already
title has to
stated,
change. Even the course title, my lord, he has to change,
Okay.
my lord. Course title also
Okay.
defective, my lord. I'm sorry, my lord, to say all
Okay,
these things.
okay.
But it's better to correct, my lord, right from the beginning.
In the meantime, Mr. Son, learned counsel for the petitioner shall file amended petition,
Course title also, my lord.
including
Expand, my lord.
in proper format, excluding the personal allegation made against the counsel or the respondents herein. List the matter on
Lordship, this kindly fix this matter on 8, Lordship. On 8 for the final disposal, because there is a
Okay.
small.
on 8th of May. On
Lordship.
that day, an endeavor will be made to finally hear and dispose of this petition.
Lordship.
My lord, I have a small submission, my lord.
Yes.
Small prayer, my lord, till such time, my lord, the disbursement of the amount may be withheld, my lord.
Pardon?
My lord, the disbursement of the compensation amount by the deputy commissioner may be withheld, my lord.
That I will not agree.
He's
to.
praying for the
Otherwise-
interim production, Lordship.
No, whether they will release the compensation?
No,
In
Lordship,
the-
not has been released.
Not released.
Not
Okay.
released.
We are in fact not pressing that, Lordship. After filing of this review petition, Lordship, we are not even pressing to the deputy commissioner, Lordship, to release. the
Okay,
petition.
till then,
No,
then,
that
the
that
compensation,
cannot be passed. My lord, I will have a serious objection to that.
no, Mr. Tara, on that day, we will finally hear and dispose of the matter. Till then, wait for something.
Yeah.
Till the next date, the compensation amount shall not be disbursed to the respondents hearing.
Only in respect to
Much
Lordship,
obliged.
small observation, only on respect of 17.62 hectare, Lordship.
Okay,
Otherwise, there will
only
be
in
another
respect of 17.6
62 hectare.
And 6 hectares, my lord.
Okay,
Hello.
6 hectares.
We are grateful, my lord.
Okay.
Deeply obliged.
Pending matters, item 18.
May it please, my lord. My lord, it was regard to the Waqf property. My learned friend is appearing for the respondent. On the last occasion, an objection was raised by my learned friend with regard to the point that the Waqf Act 1995, the suit was filed prior to the present Waqf Act 1995. So that, my lord, to respond to that, if my lord kindly has the case law which has been provided, citation, my lord.
Page number?
Rashid Ali Beg.
Page number?
Page number, my lord, would be page number 24, my lord. I'm sorry, my lord, it's page number 20.
Page number?
20, my lord.
In the judgment of the Supreme Court.
Supreme Court, my lord. It has clearly discussed.
Paragraph
on
number.
Paragraph number 13, my lord, 13 onwards.
Okay.
14 my lord, last. Can I get a copy of this one, sir? My lord, otherwise, the Honorable Apex Court has specifically mentioned all the enactments which were there prior to the 1995 Act. Prior to the 1995 Act, there was the Act of 1954, my lord, the Waqf Act of 1954. And even in that act, my lord, by an amendment of 1984, a similar provision with regard to the bar was bar of the civil court was introduced in the earlier enactment as well. My lord finds that bar at paragraph number 18. It has been discussed.
Yeah.
May I read, my lord? Section 55C barred the jurisdiction of civil court in respect of any dispute, question, or other matter relating to any Waqf property or other matter which is required by or under the act to be determined by the tribunal. My lord, this is somewhat the similar language which was there in section section 85 of the Waqf Act of 1995. So even assuming, my lord, that the suit was filed prior to coming into force of the Waqf Act of 1995.
When the suit was filed?
1994, my lord.
94.
94, my lord.
And this act was enacted in which year?
95.
Huh?
The present act is the Waqf Act of 95.
1996.
It came into force.
And no effective there.
That may not be there, my lord, but what I'm trying to impress before this court is, even in the earlier act, that is the 1954 act, an amendment was introduced in the year 1984, and by that amendment, a similar provision was inserted there as well, with regard to Waqf properties or any matter relating to the Waqf properties.
Where is that?
That
amended
provision, my lord, is discussed very well in para 18. This Supreme Court judgment has discussed all the preceding legislations which were there prior to the 95 Act.
Which is the relevant paragraph?
18, my lord, which
18.
is the section 55C barred the jurisdiction of the civil court in respect of any dispute,
So
question.
this section 55C is of which act?
1954, the earlier act, my lord. The
Okay.
act prior to this act of 1995. It was brought in by an amendment of the year 1984, and the suit was filed in the year 1994. So that amendment would apply in the suit, my lord.
Okay.
Since that objection was taken by my learned friend.
So
with
do you
regard
have
to-
the amendment, amended act? Amended provision?
Amended provision, man.
Yes.
That part, my lord, with the gazette notification could not be traced out online. Otherwise, it is.
No, is it available in the act itself?
Not in the act. The act was completely repealed, and thereafter a new act was brought in force in 1996. The earlier act was repealed.
So, Mr. Ali, you say if it was amended earlier, then the section 55C also barred jurisdiction of civil court.
Section 7, subsection 5 is very clear.
No, that is also
Suit was filed in the year 1994, and their last observation February 1994. If for a moment, if your honor kindly peruse their plan, then I will solve law provision. You will find the plan at page 48.
No, you say when the suit was filed?
This act has no retrospective effect. And
No, that's all right.
7.5 very clear. Section 7, subsection.
No,
5
when the suit was filed,
1994.
on which date?
Date of filing. Their amendment plan is there, not original plan is there. So it will be difficult without going through the.
Go through the record. Go through the record.
Ultimately, Your Honor, before coming into force of new act, and what section 7.5 says. If you are to kindly peruse this section, it is very much applying that the prior to.
Section 7 of?
Section 7, subsection 5 of the Waqf Act.
1995 Act.
1995.
No. I am of the view that section 55C, as observed by Honorable Supreme Court, the jurisdiction of civil court is barred.
Of the earlier act, my lord.
Earlier act.
This will come under the purview of section 85 of the new act. And at that time, section 85 was not there.
No. As per his submission, it was inserted in the year 1990.
in 1980. My lord, what my learned friend is trying to impress is in this act, the section 85 came into force from the year 96 onwards. What my counter submission to that is, even in the earlier act, there was a similar provision in the form of section 55C, which was inserted by the amending act of 1984.
That clarification is there, judgment of Honorable Supreme Court, if you are kindly. Synopsis is there, flag one lordship.
Into judgment doesn't.
No, you come to the judgment of the Supreme Court, paragraph number 18.
80 lordship.
18, 1-8.
Into this.
Oh, copy, copy से दे दो, मना ही नहीं मिला, paragraph नहीं मिला. But the section 7(5) and section 65 is 85 is very clear. Then this provision. If your lordship for a moment kindly. peruse.
I am not concerned with the new act.
This is of the old act.
The section 55 in earlier it is there or not? Lordship kindly. But this particular judgment is very clear, Lordship, very clear. Interpreting entire provision regarding jurisdiction.
The amendment was in 1954.
So let us do one thing. We'll fix another date. You come prepared on this point. You go through the judgment of the Supreme Court and also the amended act of 1984. Heard Mr. Soduri, learned counsel for the appellant, and Mr. R. Ali, learned counsel for the respondent. List the matter on
18 please.
for further consideration.
Deeply.
I think at 46. My lord, in this case, my name is shown for the respondent background. Into my statement, I'll in time and bring that read. My name is shown as per the order purpose chief in substitution petition, filing connection with this case matter. But your lordship was pleased to direct the appellant to take step. But step was
Taken, but.
No, now you tell me whether you have the instruction to appear on behalf of the respondent hearing.
I will take instruction, my lord.
You will take instruction.
Sometimes may can be granted, my lord.
Pardon?
Wait, কি করছে?
1 week.
Yes, my lord, 2 weeks, my lord.
Heard Mr. Das, learned counsel for the petitioner, and Mr. PP Das, learned counsel for the respondent. Mr. Das submits that he may be granted some time to obtain instruction as to whether he may enter appearance on behalf of respondent number 1 and 2. 1 and 2. Though on earlier occasion he had entered appearance for the said respondents, they are allowed to recess unless the matter after
Date may be.
On 13th, my
after 2 weeks on 13th of May.
items of information item 8.
They kindly be taken up after some time, Mrs. Soma is there.
Item 9.
May please, if you allow, please.
Yes.
My lord, here we are challenging an order passed by the first appellate court allowing additional evidence, my lord. So we were the respondents in the appeal, my lord. Originally, my lord, we were the plaintiffs in the suit, my lord. Page 18 is where your lordship finds the plaint, my lord.
So where is the impugned order?
Impugned order, your lordship finds at page 82.
Order dated 24/7/2024.
That's right.
So what wrong with this order?
My lord, if I may just quickly place the background, my lord, very quickly. My lord, it was a suit for specific performance of a particular agreement for sale, my lord. And after we filed the suit, my lord, the defendants filed their written statement, which your lordship finds at page 26. Now, page 26 for a moment, if your lordship has. My lord, they did not really dispute the agreement in question, but they said that the consideration amount reflected in the agreement was wrongly reflected, my lord. If your lordship sees paragraph 4, subparagraph, the real facts, my lord, at page 26. The real fact is that in the year last part of 2004, the plaintiff number 1 joined his services as pharmacist in so and so. The plaintiff has a business of pharmacy at the same place. The plaintiff number 1 used to sit at the pharmacy of the defendant. Gradually, both the plaintiff and the defendant became friends. Due to the long run friendship, the plaintiff wanted the scheduled land of the defendant for constructing his residence to settle there permanently. As such, in the year 2014, the plaintiffs and the defendant entered into an oral agreement. Both of them had fixed the value of land at rupees 5 lakhs only per bigha. An entire consideration for the suit land was 4,55,000 out of only out of this 1,25,000 was received as advance by the defendant. Remaining amount were to be paid by the plaintiff only after execution.
Mr. Deka,
My lord.
the petition under order 41 rule 27 CPC was filed.
Yes.
What happened to that petition?
That was allowed.
Allowed.
Yes. My lord.
At what stage it was allowed?
At the stage of hearing. My lord.
Hearing.
Yes.
Hearing of the appeal.
Hearing of the appeal. Now, to put it shortly, my lord, I filed the suit for specific performance, my lord. They said, yes, the agreement, they said, yes, we have signed the agreement, but they said that it was a sham transaction, the value was wrongly depicted, etc., etc. Now, the trial court decreed the suit and said that since you have admitted the agreement and pursuant to the agreement, you had also applied for sale permission, therefore the agreement is proved and specific performance was decreed, my lord. At the stage of appeal, my lord, they filed the application under 41 Rule 27 and they said that I want to adduce the evidence of the attesting witnesses of the agreement for sale. And that was allowed by the first appellate court. Now, what has happened here, my lord, since the agreement is already admitted, my lord, this evidence of the attesting witness in my respectful submission is unnecessary, my lord, just to delay the proceedings. Because ultimately you have admitted the execution of the agreement. So what more can the attesting witnesses say? Even if the attesting witnesses say that the execution was not complete, etc., going by your admission that issue whether the agreement was executed or not, since it's an admitted position, no evidence is required. That's number 1, my lord. Number 2, my lord, the court they have said that we did not adduce the evidence of the attesting witnesses at the stage of trial because you did not bring them. And since you did not bring them, therefore we should be given an opportunity of leading the oral evidence of these attesting witnesses. Now, my lord, first thing, what is the need for adducing the evidence of the attesting witness when the document itself is admitted? Secondly, my lord.
No, entire document is not admitted.
Execution is admitted. Execution is admitted. And attesting witnesses role, your lordship is aware, the attesting witnesses will say that this person has...
regarding that figure?
Figures, my lord, so far as attesting witnesses are concerned, my lord, they just endorse the attestation and the execution. Now, my lord, let us suppose that they are also competent witnesses to sort of adduce evidence that the contents of the agreement were wrong, my lord. Now, that they want to do it by way of oral evidence, my lord. Now, your lordship is aware of section 92 of the Evidence Act that such oral evidence in any case will not be permissible because it is reduced to writing. So what the court has essentially done is permitted oral evidence in respect of a written instrument, that too at the appellate stage, without there being sufficient proof of either due diligence or the satisfaction under Rule B of Rule 27. So, my lord, to put it shortly, my lord, first of all, I would say that the evidence that is sought to be adduced is irrelevant and unnecessary because attesting witness will merely prove execution and there is no requirement of proving execution because execution is admitted, my lord. Secondly, my lord, since all the terms have been reduced to writing, and the document itself is produced in evidence as per section 91 of the Evidence Act or 95 of the BSA, my lord. Now, oral evidence to either vary, contradict, or modify the terms of contract would be impermissible under section 92, my lord.
No, not permissible, all right. Let the trial court consider it after examination of those witnesses.
Well, trial is over.
Trial is over.
Trial is over, my lord. This is the stage of appeal, my lord. Now, just last month, the Supreme Court has passed a judgment that insofar as additional evidence is concerned, that is rarely to be granted. Only on the satisfaction of the requirements of Rule 20.
No, Mr. Deka, you see, considering the submission of both the parties, the trial court has exercised its discretion.
My lord, that's
Whether
discretion
in revision petition we will substitute the view of this court.
that is exactly my ground, my lord. That the exercise of discretion has been done wrongly, my lord. And for that, I'll
No, whether oral evidence will be admissible in evidence or not,
my lord.
that will be decided at the time of final hearing.
My lord, firstly, my lord, because Rule 27 is very clear, my lord. That is what the Supreme Court last month had said. It starts with a negative. No evidence should be adduced in an appellate.
Where is that?
I'll just fix it.
And Mr. Mukherjee, what is your stand?
It is the first evidence that is taken. The final court of facts, the learned court has considered the pair and
No, there is no dispute regarding the execution of the agreement.
But the
Dispute is only in respect of the figure.
and that will be vital because it is a suit for specific performance of contract. Unless the consideration is determined, entire suit. And starting whatever document was submitting under 227, Your Worship, I have just came across a judgment delivered yesterday by the court, Your Lordship. It says that under 227, materials that were considered by the trial court, factual materials, cannot be reassessed by the High Court. That is what they have relied on 2017 judgment. And yesterday, judgment by the Apex Court, Your Lordship.
Yesterday.
Vinay Raghunath Deshmukh versus Natwardal Sanj Gada, 24/4/20.
It is available with you.
Lordship, I will just get a printout.
Okay.
I was just going through now.
Produce it. Let it be on Wednesday then. Heard Mr. Dekar, learned counsel for the petitioner. And Mr. Mukherjee, learned counsel for the respondent. List the matter on Wednesday for further consideration. In the meantime, Mr. Mukherjee, learned counsel for the respondent, shall produce the judgment relied upon by him.
Obliged.
Yes, this is transfer petition.
Yes, your lordship. this
From
is a
which place
transfer,
to which place?
From Sribhumi district to Silchar Kachar.
What is the distance between the two districts?
That is 55 kilometer from her home.
Mm.
And she is a tuberculosis patient, my lord. And she is
The suit copy, plain copy, they have managed. There it is specifically mentioned that he is 71% suffering from 71% paralysis. And this is as they have filed the document as annexure. This is an admission, your lordship.
Mm.
And they have filed.
Then you produce the document, we will see.
This is annexure 1, page 12.
Heard, Mr. Your name, please?
R.D. Gupta. Your
R.D.
lordship.
Gupta, learned counsel for the petitioner. And also heard Miss
D. Chaudhary, Devolina Chaudhary.
D. Chaudhary, learned counsel for the respondent. You want to file objection here? The learned counsel for the respondent submits that he has received a copy of this petition on last date. And she prays for granting her some time to file objection in this petition. Prayer allowed, recessal is the matter on
Your lordship. 11
suggest the date.
5. 11/5 would be convenient.
After May, if possible.
Your it will be very long.
Then before 15, your lordship, it will have the authorization.
15th of May.
11th, your lordship.
All right, Supreme, Mr.
11th May.
11th May is okay, no? For you,
Before May.
Yes,
consider.
yeah,
Before 15th of May,
yes.
11th of May.
Your lordship, our another submission is that your lordship kindly still proceeding in
The
the
petition is not there, your lordship.
your
No,
lordship.
here, there is no prayer
in
for
the
staying
disposal of this petition
Hmm.
in that in title suit 35.
the. What is this? The suit is pending.
In PWs, your lordship. In PWs, that case is pending in PWs.
Evidence stage.
Evidence.
Evidence is this.
The last stage, your lordship.
There is no prayer here.
Let's see.
Okay, on next date, we will finally hear and dispose of the matter.
Yes, your lordship. Okay.
Pending item 8. Pending item 8.
Lordship, may please come to the trial court order first, Lordship. It's very interesting case, Lordship, because I have also not read this provision. The petition was there, like the Order 22 Rule 9 petition, Lordship. But this is a specific case of Order 22 Rule 10, Lordship. And there is a vast difference, Lordship, and there is a Supreme Court judgment on this directly. Lordship, what, Lordship, before I go to the other thing, let us read the plain first, Lordship, at page 29. Page 29, Annex 1. Lordship, page 29.
Yes.
Get it. So this is a certified copy. Lordship, all this left-hand side, all these people are this substituted name and all that. But Lordship, you can see in bold, the suit for declaration, partition, allotment of share, value the rupees 1 lakh. Lordship, get it? So there is a question of allotment of share, there is a question of partition, and then declaration, Lordship. Now, Lordship, we'll come to the prayer first, the prayer portion. There is two type of prayer. At para 13 at page 33. The plaintiff therefore claim and pray for a preliminary prayer is that if the defendant number 1 produce in written statement the Waqf of decree, this is not there, Lordship. So they have filed written statement, they said no. So this preliminary part has gone. The second part, if no written document of work is produced by the defendant, then an alternative decree declaring 3/8 share of each plaintiff number 1 and 2 in the property of Schedule A. Lordship will take note of this. Because Lordship, Mohammedan law, it is very confusing, Lordship. I have seen the things, Lordship, yesterday. So then after going to the judgment only, I came to know all this, Lordship, that there is some difference between the normal substitution and all that and abatement and all. Because the facts is different, Lordship, in this case. Declaring the 3/8 share of each of the plaintiff number 1 and 2 in the suit property Schedule A, along with the 3/8 share in house rent as in date of the filing. A decree for the partitioning the property and allotment of the share through pro forma defendant number 1 in the authority of making partition in the field. A decree of other ancillary relief which the plaintiff are entitled to have in preserving the Waqf, and this is nothing to do now, Lordship, because the preliminary is not there. What is the suit here, Lordship? The defendant number husband is the owner of the property. The defendant number 1, husband, is the owner of the property. The plaintiff number 1 and 2 is the sister. Plaintiff number 3 is the husband of the plaintiff number 2. So this is the fact. Now, Lordship, the plaintiff number 1 died, defendant number 1 died, all these people died. And Lordship, the very interesting, Lordship, all these is issueless. So the complications come. What happened during the pendency of the suit? The defendant number 1 died. So, defendant, after the death of the defendant number 1, her brothers, sisters, all of them were substituted. They appeared before the court. They said, we have nothing to do. We do not want anything from this suit property. And they filed the affidavit. I'll go to that, Lordship. It is the matter of record, Lordship. They said, we do not want anything. In the meantime, Lordship, the defendant number 1 sold a portion of the land to my learned friend client. We have no dispute, Lordship. In this case, 9.9 lesser. He is entitled, Lordship. We do not want to challenge that also. Lordship, let him get it. What happened, Lordship? When the plaintiff number 1 died, when the matter was pending, the plaintiff number 1 and 2 has given a power of attorney to 1. Secondly, an assignment deed, Lordship, that is at page 70, Lordship. Page 70. Lordship, page 71, sorry. It is annexure 6.
Yes.
So this is the deed of assignment, Lordship, under the section 130 of the Transfer of Property Act. See, both she said they have given in favor of the Vikas Kumar Sethia. Lordship, get it. Now, Lordship, interestingly, this Vikas Kumar Sethia, Lordship will take note at page 29. Lordship will take note of page 29. Vikas Kumar Sethia is the defendant number 3. He was a tenant in this suit property. Vikas Kumar Sethia. So this assignment deed was given by the plaintiffs 1 and 2 to defendant number 3. And there was consideration, Lordship. They took money and all. Lordship, may please come to page 75. Page 75. Lordship get it? I'll read the paragraph 4 first. That the assignee shall have every right to contest any with respect to the property of title suit number 337 of 2008. This page 29, Lordship. And file any other suit in the name of the protection, protect the property and assign to him. That the part of the land is already in possession of the assignee in the land of Schedule A, and he will remain in possession thereon. That in pursuance of deed of assignment, the assigner has already received substantial amount in 2 installments by executing a document in so and so, and they received today a sum of rupees so and so. 7. The assignee shall do all the needful. Lordship, this is necessary. That the assignee shall do all the needful as necessary for conducting the aforesaid title suit number 337 of 2008 up to the stage of the final verdict, and shall bear the entire expenditure of the suit and his execution. Pausing for a moment. Lordship, now please come to the CPC. Order 22, Rule 10. Normally, Lordship, we deal with Order 22, Rule 3, 4, and 9. Lordship, the 10 is different from the 9. Because the abatement and all that, we normally deal with the Order 22, Rule 3, 4, then the 9, and then the court decide. But 10 is something different, Lordship. Because the suit is abated when the plaintiff number 1 died. So, Lordship, I have to keep in mind that the plaintiff number 1 died, and plaintiff number 1 has assigned the defendant number 3 to take care of the property, and for the purpose of the decree and all that, he will, as an assign for this purpose. Now 10, Lordship, Order 22, Rule 10. In other cases of an assignment, creation or deviation of any interest during the pendency of the suit may, by leave of the court, be continued by or against the person to or upon whom the such interest come or devolve. So this case, Lordship, the plaintiff number 1 died, suit abated. So the defendant number 3, as an assignee, has filed an application to vacate the abatement order.
What wrong with that?
There is no wrong, Lordship. The court said, no, you cannot.
Okay.
That's my point, Lordship. And my learned friend has no problem, and nobody has filed any objection. The most interesting part is my learned friend, client, he has not filed any objection. All other defendant, even the plaintiff, no one has filed objection. The court, out of his own court thought that it is 20-9, and court decided that you cannot. Lordship is very correct. What is wrong in that? Because everything is settled. Because somebody have to take care, this should have to be declared. Plaintiff number 2, plaintiff number 1 died. So plaintiff number 2 has no objection. My learned friend client has also not filed any objection. Nothing. But the court decided the application against me. So now, Lordship, may please come to the order. Both the orders. I'll read the order of the trial court. At page 78. No. So, Lordship, I'll read. No, sorry, I got a topic.
Yes.
Lordship, before that, I'll read only one page, Lordship. Lordship will allow me to read the page 78, Annexure 7. Order dated 9/11/20. The plaintiff number 2 and the defendant number 2 are represented. No steps was taken to substitute the legal heirs of plaintiff number 1. Prosecuted. The suit is abated against the plaintiff number 1. The suit is also proceeding expert against all other defendants. Now, Lordship may please come to the impugn order, the order of the trial court at page 82.
Yes.
Page 82.
Yes.
And my application to vacate the abatement order and is at page 79, Lordship. That I will read. As an assignee, I have filed the application at page 79 to setting aside the abatement order, Lordship. And I have annexed all these assignment deed and all. The plaintiff number 2 and the defendant number 2 are represented. Petitioner Vikas Kumar Sethi is represented. Today is fixed for order on the petition number so-and-so filed by the petitioner Vikas Kumar Sethi. The petitioner was filed for setting aside the abatement order passed against the deceased plaintiff number 1 so-and-so under so-and-so and read with 10-1 prosecuted by the petitioner as a assignee. The plaintiff number 1 in the present suit was passed away, and as no legal heirs were brought on record, the suit abated against the plaintiff number 1 by the order dated so-and-so. The petitioner claimed to be the assignee of both the plaintiff number 1 and 2 on the strength of the legally enforceable deed and registered deed of assignment executed by both the plaintiff on 24/5/2005, deed of assignment number so-and-so before the sub-register petitioner in the capacity of being the assignee as per the aforementioned provision of the Civil Procedure Code, prays that the order of the abatement be set aside and he be substituted as the plaintiff number 1. A photocopy of the original deed of the assignment is appended to the petition. Heard the learned counsel for the petitioner plaintiff number 2, the counsel for the defendant did not make any submission. The counsel for the defendant did not make any submission. Now the first line of the deed as being deed of assignment, actionable claim under so-and-so, so-and-so. Coming to the definition of actionable claim under the so-and-so, actionable claim means claim of any debt other than the debt of secured mortgage in movable property or by hypothecation of the place movable property or to beneficial interest of movable property not in the possession either actual or constructive of the claimant in the civil court recognized as the ground of the relief, whether such debt or beneficial or so-and-so, echoing conditional or contingent. But as per the deed submitted by the petitioner, which is registered as deed of assignment by the so-and-so, have transferred the share of the land and the title which they have sought as a relief of this case. It is not, my lord. The legal share of the title of the interest so-and-so, 3/4 share of the Schedule A of the plaintiff, came as thereon on the date of the brother Samsul Bari, is purported to have been transferred by the deed of assignment. The deed also mentioned that as the name of the plaintiffs are not mutated with the suit property, no sale deed could have been made. Therefore, the share of the plaintiff was assigned by the executing the deed of the assignment and deed to transfer all right title interest which may be decreed in favor of the plaintiff in the present case. Now, for transfer of title of immovable property, there are various ways of instances. So he said that the how to transfer. Then the last paragraph. Moreover, the plaintiff was seeking share in the deceased brother's immovable property, but the wife of their brother claimed that she was gifted the entire suit property, and therefore the crux of the present suit is whether the plaintiff have any share in the brother's property in the first place. Therefore, at this stage, it cannot even determine whether the plaintiff number 1 and 2 are competent to transfer the section 7 of the Transfer of Property Act. So, Lordship, here the court has not looked into the thing that this is not the Hindu law, this is Mohammedan law, and the Mohammedan law, the share, how the share will go, it is very clear, and the gift deed and all that things, and now after the death of the defendant number 1. Her legal age has come and they have filed their affidavit. That no, we have no problem if the things go to the plaintiffs and the whatever. Now, he has at page 85, he has decided like this. Therefore, in the light of the above discussion consideration, I am unable to hold that the petitioner as assignee of the plaintiff and therefore he has no locus standi to file an application for setting aside the order of abatement against the plaintiff number 1, and the petition is not maintainable, hence rejected. So that is the trial court order lawsuit. So according to him, the assignee has no right. So against that, in fact, lordship, there was a civil revision file. It was wrongly filed, lordship, withdrawn, and then appeal file. And in the meantime, Azizur Rahman also died. The defendant number 2 also died. So that is at page 88, lordship. Now, lordship, at page 89, lordship will get that the plaintiff and 1 and 3 died and all that. These things has come to the knowledge. And lordship, then page 89, lordship, this that the all other substituted person has come and they have filed it. That is there at page 89. What I have said, lordship. Another petition number so and so, when you with the prayer of substitution legal yes of the, this is defendant number 2. It is stated by defendant number Aziz Rahman passed away on so and so, a copy of that declaration certificate that the issued in the hospital is submitted with the petition as death certificate has not yet been issued. The name of the legal heirs are as follows: so and so, so and so, so and so. All the resident numbers so and so and so and so. The legal heirs are duly substituted as defendant. The bench is then directed to include the name of the legal heirs in the plain petition. Accordingly, petition is disposed of. Now, lordship, all those persons were made party, and let us see what they have filed before the court. Petition petition. এখন দেখালে হল, এখন যে কোনো Yes, lordship, may please come to page 51. From 51, it is collectively all of them has filed. These are the legal heirs of defendant number 1. Page 51 onward, lordship. Lordship, in the 52, paragraph 4, that the defendant number 1 is most respectfully beg to state that under the circumstances, defendant number 1 has no objection if the honorable court allowed the primary or secondary prayers in favor of the plaintiff as prayed for in so and so pending before this court. So they have no problem. All the substituted person, they have filed their affidavit before the court, all of them. The same. 1A, 1B, and 1C. Then 1D. Then 1E. Up to page 64, lordship, 65. All of them has filed. That they have no problem. Now, lordship, the impugn order, lordship. He has gone further, lordship, from the trial court. The appellate court has gone beyond the lordship. Even the trial court, what the trial court said, he has go beyond. Page 91, Annexure 13. Let's get it. Now, at page 92, he has started the appeal under so and so against the order dated so and so, so and so. And lordship, may please come to page 96. Paragraph 8, lordship, point for determination, page 96. From the ground of the appeal and the pleadings of the parties, the following point for determination emerge an appeal. Points for determination in this appeal: whether the order dated so and so passed in title to the learned judge so and so Dubri rejecting the prayer of the appellant to represent the suit on behalf of the assignment did is sustainable in law and fact. Discussion and media, reason thereof, and he has quoted all these paragraph DEA. This is the order passed earlier Then is page 97, last part, Lordship. Now, Lordship, get it. Page 97. Now, he has quoted the trial court order and all that. Then his finding is page 97, last part, Lordship. Now, if you see the recital of the assignment is so-and-so observation of the learned trial court, we will find that the observation of the learned trial court appears to be logical and correct because the assignment deed in dispute is nothing but the sale deed in disguise and is not enforceable in view of the section 32 of the Contract Act and all that. And section 7 of the transfer of property, as is the ownership of title of assignment so-and-so is sub judice, and the assignment, this sub, even if it is sub judice, Lordship, Lordship, and the assignment did not be executed in respect of the immovable property if the assignant has got no title to the property. So accordingly, with this finding, he has dismissed by petition. Accordingly, above background, the order that is so-and-so learned transaction hereby avail in consequence the appeal is dismissed and contest. Now, Lordship, while reading yesterday, Lordship, the whole case, Lordship can take this because only the I have given the page and the EA, Lordship, only. Why in the first page, last EA, Lordship, why the deed of assignment was made and the principle of estoppel is not applicable. During the lifetime of defendant number 1, the scheduled property was devolved upon the strength of the oral gift made by her, this is husband, late so-and-so, which the plaintiff came to know from the WS filed by the defendant number 1. Moreover, the defendant number 1 sold out 9.9 lasses of land to the defendant number 1 by defendant number 2, Lordship, not defendant number 1, Lordship. By registered sale deed. That the petitioner denied the title of the plaintiff in his written statement because the relevant point of so-and-so and then all that. So according to my Lordship, the defect in the impugn order is what is the wrong. As per the impugn order at page 98, the learned first appellate court hold that the assignment deed is not enforceable in view of the section 32 of the Contract Act, reduced section 17 of the Specific Relief Act and section 7 of the TP Act, as ownership title assigned the plaintiff number 1 and 2 is sub judice and they cannot be executed assignment so-and-so. So all these things he has decided, Lordship, but position to the Supreme Court. There is a Supreme Court judgment, Lordship, that will clarify all these points, Lordship. 2001, 6 SCC 534. Lordship, this is the main case, Lordship, and then subsequent, this relying on this, the Supreme Court has given as argument in 2016, Lordship. Lordship can take this because that is a long judgment, Lordship. Here the Supreme Court has quoted 2 paragraphs from that judgment, Lordship, from 2001 6 SCC 534. Lordship, here in 2016, 1 SCC page 730, Lordship, may please come to paragraph 6. Or I can start from paragraph 5, Lordship. Supreme Court first has quoted the Order 22 Rule 10 and 11 in paragraph 4. Then in paragraph 5, at page 732. The Supreme Court says a bare reading of the provisions of Order 22 Rule 10 makes it clear that the legislature had not envisaged the penalty of dismiss of the suit or appeal on account of failure of the assignee to move an application for a Lordship para 5. I'm reading para 5 at page 732. (2016) 1 SCC Lordship. Para 5. A bare reading of the provision, Order 22 Rule 10 makes it clear that the legislature has not envisaged the penalty of dismissal of the suit or appeal on account of the failure of the assignee to move an application for impleadment and continue the proceeding. Thus, there cannot be a dismissal of the suit or appeal, as the case may be, on account of failure of the assignee to file an application to continue the proceeding. It would be open to the assignee to continue the proceeding, notwithstanding the fact that he ceased to have any interest in the subject matter of dispute. He can continue the proceeding for the benefit of the assignee. 6. The question is no more recently in case so-and-so, that is, I have given Lordship. This is the 2001 6 SCC 534. Now Supreme Court, the 2001 6 SCC 534 I have given Lordship. That is there. So this court has now quoted the paragraph 6 from 2001 6 SCC 534. In order to appreciate the points involved, it would be necessary to refer the provisions of Order 22 of the Code, Rule 3.4, where it prescribes the procedure in case of devolution of interest on the death of a party to a suit. Under this rule, if a party dies and the right to sue survives, the court, on an application made on his behalf, required to substitute the legal representative of the deceased party or the proceeding with the suit. But if such application is not filed within the time prescribed by the law, the suit shall abate so far as the deceased party is concerned. Rule 7 deals with the case creation of interest in the husband on the marriage, and Rule 8 deals with the case of an assignment of the insolvency of a plaintiff. Rule 10, now Lordship, this is my case. Rule 10 provides for seasons of assignment, creation, and devolution of interest during the pendency of the suit, as in my case, Lordship. Then those referred to in foregoing rules and is based on principle that the trial of a suit cannot be brought to an end merely because the interest of a party in the subject matter of the suit has devolved upon the another during its pendency, but such a suit may be continued with the leave of the court by or against the person upon whom such interest has devolved. But if no such steps is taken, the suit may be continued with the original party, and the person upon whom the interest has devolved will bound by to take the benefit of the decree, as the case may be, unless it is shown in a properly continued proceeding that the original party, being no longer interested in the proceeding and did not vigorously prosecute or colluded with the advisory, resulting in decision adverse to the party upon whom the interest is devolved. As in my case, because the plaintiff number 2 and A, they have lose interest, Lordship. They got the money and they are not appearing in the case now. And the all others have already filed affidavit. They said, we are not interested. We do not want anything. The legislature, while enacting Rule 3 and 4 and 10, has made a clear-cut distinction. In cases covered by the Rule 3 and 4, if the right to sue survive and no application for bringing the legal representative of the deceased party is filed within the time prescribed, there is automatic abatement of the suit, and procedure has been prescribed for setting aside the abatement under the Rule 9 on the ground of the postulated therein. In cases covered by Rule 10, the legislature had not prescribed any such procedure. In the event of failure to apply for leave of the court to continue the proceeding by or against the person upon whom the interest has devolved during the pendency of a suit, as in our case, Lordship, which shows that the legislature is conscious of this eventuality and has yet to have prescribed the failure to entitle dismissal of the suit, as it was intended that the proceeding would continue by or against the original party, although he ceased to have any interest in the subject of dispute. In the event of failure to apply to leave to continue by or against the person upon whom the interest is devolved for bringing him on record. Then under Rule 10, Order 22, the court, when there has been a devolution of interest during the pendency of the suit may, by the leave of the court, be continued by or against person whom such interest is devolved, and this entails the person who has acquired an interest in the subject matter of the litigation by an assignment or creation or devolution of interest, pendant right, or the suitor or any other person interested to apply to the court for the leave to continue the suit. Pausing for a moment. This covers my whole thing. And the first line uttered from a lordship mouth, that what is the wrong? There is nothing wrong, lordship, during even the pendant right and everything the Supreme Court has covered now. Because Supreme Court said 3, 4, 9, all these things are different, and Rule 10 is different. And pendant right and the during dependency, everything is covered, as in our case lawsuit. Now the appellate court said during dependency you cannot do. Trial court said the suit was pending, how the assignment deed was signed, all this. So all these things is covered, lawsuit. So there are two other High Court judgment lawsuit. I don't think lawsuit after this Supreme Court the same line lawsuit, but the
Okay.
lawsuit.
You have no objection. Okay. Heard
No,
Mr. Sharma, learned senior counsel, assisted by Mr. Bhunya, learned counsel for the petitioner, and Mr. Learned counsel for the respondent number. Respondent number 1.
One.
Respondent number 1. You for? Respondent number 2. Anything to submit? You? No. Argument concluded, order is up.
Numbers 13 and 14.
May I please, lordship?
Review petition, my lord, I'm withdrawing when I have instruction to withdraw the review petition.
Item 14, I think.
Which one?
Item 14, they have filed the review petition. State has filed the review petition, my lord. They are not pressing it. And item 13 is the writ petition, my lord.
In a review petition, you are the petition.
Yes, but state is.
Okay. Ms. B. Chakraborty, learned counsel for the review petitioner, submits that she has the instruction to withdraw this petition. Accordingly, this revision petition number so and so is disposed of on withdrawal.
Yes, my lord, item 13. Although my lord, these are related matters, I find some new facts have come. I would like to file an affidavit for this matter.
My lord, they have taken time in this writ petition, my lord, on many occasions, my lord. But the fact is that the schools are suffering, my lord, and the students are suffering. We are the guardians of the schools, special schools, my lord. And our schools are not having the regular principal, vice principal, and the teachers, and as well as the infrastructure development are also not there. And the my lord,
Okay, let her file affidavit.
yes, Lordship, let them file affidavit.
Short date.
Yes, short date may be
Or
given.
Mr. P. Purkaisto, learned counsel for the petitioner, and also heard Ms. Chakraborty, learned counsel for the respondent. You are for all the respondent. Ms. Chakraborty submits that she will be granted some time to file affidavit in this matter. Fair allowed, recessal is the matter. After 1 week,
Yes, to
So I for 1 and 2, my lord.
1 and 2.
1 and.
Seventh of May, my lord. 7th of May.
Total service completed in other restaurant.
Yes, my lord, all respondents are appeals. State respondents, all are state.
Which one is? In the second week.
I mean, it will.
I don't know. You can't do more after that.
How to go? 7th of May. 7th of May. 11th of May. 11th of May.
So, Madam AOC, on 12/12/2025, you entered appearance.
Yes. 12/25.
12/12.
Yes, yes.
Finance of the Standing Council and Government Personal, my lord, GA Assam. All of that.
We don't know. Yes, we got the case.
Okay. Madam, we are fixing it to 7 then?
Can it be second week?
11th.
43.
Lordship, Respondents' Council is not clear. In earlier occasion also, Lordship, he abstained from participating. Lordship.
E.K. Mozumdar, do you know him?
Lordship,
You know him?
Lordship.
Corey, can you inform the other side? No. The name is also reflected in the cause list.
Lordship, name is reflected. Last time he took time. Last time he took time.
Let it be on some other day.
Lordship, it may be fixed. Lordship, date may be.
Heard Mr. A. Islam, learned counsel for the petitioner. None appears for the respondent. To Mr. P.K. Majumdar, learned counsel entered appearance on the on 30/3/2026 and pride for adjournment. List the matter on 15 May.
12. 12.
12.
It's an admission letter on Monday, Wednesday or Friday.
It is
15.
Items under order.
obliged.
Items for hearing under order 41. Item 16.
It was. May pleasure.
So, Mr. Roy, you have suggested as many as 13 substantial question of law.
With Lordship, I have sorted out again.
Yes,
Lordship,
as
we
many
need
as
to come to
13.
Page number 26, Lordship.
Yes.
Serial number 1, 3, 4, and then Lordship 7, page 27, page
1, 3, 4, and 7.
7, and lastly Lordship 12, page 29. So that will serve the purpose.
So, you see, come to suggested substantial question of law number 3.
3.
Yes. Here, there is concurrent finding of fact by both the court below that Article 56 will be applicable here.
Lordship, that is the blunder mistake. Lordship, Article 56 applies of the Limitation Act where any sale deed or gift deed or exchange or any transferable property which registration is compulsory, that applied, Lordship. My suit was for declaration of right title interest lordship. And that will be covered under Article 58 of the Limitation Act. Limitation is 12 years. And in case of Article 58, limitation is only 3 years. I was surprised, Lordship, how a senior division judge will commit such a mistake in dismissing the suit and holding that suit is barred under section Article 56.
No, in respect of 58 also, what is the period of limitation?
What, my lord?
58.
58.
Yes.
58, Lordship, 3 years when the right to sue survives. Survives, 58. And 3 years. And in the present case, Lordship, when the right to sue arose, Lordship, then it will be counted from the date of knowledge. What happened in this case, Lordship? The defendant, Lordship, got mutated his name in the Javamandi, your Lordship. Because, Lordship, the father of the defendant were working as the superintendent of the office of the DC, Lordship. So, in collusion with the circle officer, the name of the father of the respondents was mutated in the Jamabandi, Lordship. And there is actually no cell deed, Lordship, nothing, no deed, other convenience registered deed, Lordship. And this respondent father, Bhagwati Prasad Das, he was the nephew of the father of the present appellant, Lordship. But his name was recorded that as if he was the legal heir of late Devi Prasad Shah. Surprisingly, Lordship, pleased to peruse this exhibit 26 I have annexed. After mutation of the name of Bhagwati Prasad Das, Lordship, in the last settlement operation, the patta was issued in the name of the father of the appellant, Lordship. That vital aspect was not considered by the learned, both the courts below. That your Lordship may be pleased to come to the, I have an additional affidavit, Lordship, annexing that annexure, Lordship. Page, Lordship, page 34 here of my additional affidavit. Well, where's the applicable article? Years difference. Huh? 56, 58, Article 58. Yeah, yes.
Page number 34.
Lordship.
Page number is 34.
Page, Lordship, 34. Yes. Page 34, Lordship. In the last settlement operation, Lordship, as because the defendants were never in the possession of the suit land, and earlier Pattadar was the father of the present appellant, Devi Prasad Das. So that's why this patta was issued in the name of the Devi Prasad Das, who is the father of the present appellant, Lordship. And this vital, nowhere in the entire judgment of the both the learned courts below, there is a whisper regarding this vital document, Lordship. It was not considered at all, Lordship. Because, Lordship, if they would have been in possession, a respondent would have been in the possession of the suit, and the pata would have been issued in their name. And here, Your Lordship, this pata was never challenged by the defendant till date. Apart from that, Your Lordship, may please to come to the what happened here when I come to know that the name of the defendant has been mutated, Your Lordship. I filed an application before the office of the DC Deputy Commissioner Dibrugarh for obtaining the certified copy, Lordship. And then, Your Lordship, may please to come to page 30 of that additional affidavit. Lordship, got it? Page 30, additional.
No, which article will apply? Article 56, 58, or article or section 17?
Section 7, Lordship, this page 30, Lordship. This is the letter issued by the DC office, Dibrugarh, Lordship, in the name of the present appellant, stating that with reference to the above, I would like to inform you that old case records of partition case number so-and-so and the mutation case number so-and-so, for which you prayed for certified copy could not be test out in this office. Hence, furnishing of the certified copy against these cases could not be done. So, Lordship, I have personally argued my case in the Court of the Learned Senior Division, Dibrugarh, Lordship. I have placed the judgment of the Apex Court, Lordship, that as per Section 17 of the Limitation Act, if a certified copy is not supplied, then the limitation will run in rem, Lordship. And that Your Lordship is pleased to take up the Section 17 of the Limitation Act. Section 17. Yes. Effect of fraud or mistake where in case of any suit or application for which a period of limitation is prescribed by the Act, the suit or application is based upon the fraud of the defendant or
respondent or his agent, or B, the knowledge of the right, the knowledge of the right of the title on which a suit or application is founded is concealed by the fraud of any such person as aforesaid. C, the suit or the application for the relief from the consequences of a mistake, or where any documentation necessary to establish the right of the plaintiff or application has been fraudulently concealed from him. This is important. The period of limitation shall not begin to run until plaintiff or the applicant has discovered the fraud or the mistake, or could with reasonable diligence have discovered it. In the case of a concealed document, until the plaintiff or the applicant first had the means of producing the concealed document or the compelling its production, lordship. So, lordship, ultimately the DC office informed that actually
No. Where it is stated that from the date of receipt of certified copy, the limitation will start.
Lordship, the period of limitation shall not begin to run until plaintiff or applicant has discovered the fraud or the mistake, or could with reasonable diligence have discovered it, or in case of a concealed document, until the plaintiff or the applicant had the means of producing the concealed document or compelling its production, lordship. So my humble submission is this, lordship.
No, whether certified copy is provided here.
Because the certified copy was not provided, your lordship has already gone page 30. Certified copy, judgment is there on this point of the apex court, lordship. Yeah. Huh?
This is of Calcutta High Court.
This is Calcutta High Court.
Yeah.
And I am having this.
Which paragraph you are relying on?
Lordship, this is para 12 of Calcutta High Court.
Where it is stated about the certified copy?
Your lordship, the next page, second page, lordship. Article 123 of the Act would begin only when the applicant has discovered the mistake, or could with reasonable diligence have discovered it. In other words, on the findings of the two courts below, which we have the reason to disagree. So, lordship, this may be, I could not do homework properly. This may be taken on Wednesday.
Wednesday. Not Wednesday, on Thursday.
Okay.
Thursday.
There is a Supreme Court judgment.
But this is of Calcutta High Court judgment, and nowhere in this judgment this certified copy is dealt with. Heard, Mr. S.P. Roy, learned counsel for the petitioner. No, for the appellant. List the matter on Thursday for further consideration.
All right.
May I please, my lord? My lord, this is against the concurrent finding, my lord. And my lord, the substantial question of law is at page 8, my lord. Page 8, my lord. My
So
lord,
perverse on what ground?
my lord, the finding, my lord, that with regard to, my lord, the case of, my lord, here the appellant before your lordship is the defendant, my lord. The case of the plaintiff is that, my lord, in the year 1974, he took a shop house on rent from the Tinsukia Municipal Board, my lord. And in the year 2008, in the month of October, when he come to Gauhati, and when he returned back in November 2008, he discovered that the shop house was, my lord, divided into 3 parts, and, my lord, it is given on rent to the, my lord, defendant number 4 and 5, my lord. But all this finding, my lord, with regard to his possession and dispossession is, my lord, nothing is proved, my lord. Rather, my lord, in his cross-examination, stated that, my lord, in 1974, he was 17 years old. And, my lord, in the cross, my lord, I have annexed the documents, my lord. My lord, earlier to that, my lord, with regard to, my lord, substantial question number 1, my lord. If lordship may take up, my lord, page number 121, relevant will be 122, my lord. My lord, the plaintiff in this case, at 122, my lord. The plaintiff in this case, my lord, has filed one petition for summoning, my lord, official witness from Tinsukia Municipal Board. That was rejected, my lord. Against
122.
122, my lord. That will be the
It
relevant.
is CRP number 247 of 2013.
Yes, my lord. This may read, my lord.
So how this order will help you?
My lord, this honorable court, my lord, directed to call the witness from the municipal board, but has not allowed to adduce any document as a plaintiff exhibit, my lord. But in this case, my lord, trial court has not only allowed the PW3, who is from the municipal board, to adduce the exhibits as the evidence, my lord, and also relied on that the said documents, my lord. If lordship may come to page 69, that is the relevant portion of the trial court judgment, my lord. By relying on the judgment of that documents produced by the witness from the municipal board, the court has come to the finding that the suit land was allotted in favor of the plaintiff, my lord. Page 69, my lord.
No. In this order, it has been observed that there was no pair in the petition.
Yes.
For production of the document.
Yes.
So this court has allowed to examine that witness without calling the document.
Documents, my lord. But the said witness, my lord, has adduced the evidence and, my lord, produced the documents.
No.
From exhibit, my lord, 7 to 12. And by relying on that documents, my lord.
No, without, however, directing the here the this observation that, however, without however, directing it to
production of any document.
To produce any documents.
Yes, my lord.
So though the court has not directed, if the witness produce the document, then.
My lord, my understanding is that, my lord, this court has, my lord, restrained the witness from producing any document.
No. That kind of interpretation cannot be given.
Because, my lord, the court has modified the impugn order by saying that the witness can be produced, but he cannot produce any document, my lord.
No. That is not the intention of passing this order. However, without, however, directing it to produce any document from the record.
Yes, my lord.
But if the witness produce those documents, then
My lord,
can you debar him from producing any document?
he is a official witness, my lord. And, my
maybe.
lord, in their petition, they have not made any prayer for producing any document or
Hmm.
anything, my lord. So that's why the trial court has earlier rejected. Then this honorable court says, okay, let him produce, but he will not produce any document, my lord.
No, without, however, directing.
Yes, my lord.
So, whether that order by which the witness was called for, person to this order, is part of this record?
After this trial court order, my lord.
No, after the order of this court, what order was passed by the trial court?
Yes, my lord. Well, that I have not annexed with this appeal, my lord.
Whether it is available with you?
Yes, my lord.
Here.
No, not with the record. I have the copy of the order.
You file it, then we will see whether this order of this court has been complied with, and if so, how it is complied with. What was the consequential order passed by the learned trial court pursuant to this order?
I will file it.
But the question is that you cannot debar any witness from producing any document.
They have exhibited, exhibit A, the other one is, the other one is admitted by me, that I am the tenant of the tenant of the road, and also admitted in the cross. This is the cross. The cross, and we are on page 70. Page 70. The schedule,
Page 17 is an affidavit.
70.
70.
Correct. Their document, exhibit A. All, although PW1 deposed that there was no agreement or tenancy or preparation in his name by the Community Board, but it is recorded and admitted fact that suit schedule A is recorded in the name of plaintiff. Although the DL1 and DL2 deposed the sub SS1 and SS2 were taken by Mukti Nath Protocol in the name of plaintiff, there was no supporting evidence in this regard that Mukti Nath Protocol took the suit premises under tenancy. Later, if you believe exhibit A is proof, their document. Still it appears on exhibit A that the name of plaintiff Vijayanath Protocol is mentioned as purchaser. So from their exhibit, my name is there. From their document. And about this.
No, Mr. Gogoi, you see, we are concerned with the substantial question of law suggested by the appellant.
Even though the PW3 has proved my document, exhibit 1 to 4. I read it, page 69.
No, Mr.
59.
Mr. Gogoi,
Yes.
you see, you come to the substantial question of law number 1 suggested by him.
Yes, sir.
So here the question is whether the court below committed error by relying upon exhibit 5 to 10 while passing the impugned judgment in view of the order dated 8/11/2013 passed by this court in CRP number so and so.
Here in the
So the issue is what are the exhibit 5 and 12?
Yes, yes.
And how these exhibits were produced before the court?
Yes. At the time of cross-examination, Your Honor, they have not objected to it, and they have not put under objection. In the once it is exhibited, how in the they can raise it, because in the time of cross they have participated and they essentially cross the PW3.
No, you tell me what are these exhibit 5 and 12, 5 to 12? What are those documents?
Some of the documents which are the demand register, of the tenants who are in our teaching report. Apart from it, exhibit 1 to 4, this is my document. He has stated that this is issued from
No, no, we are not concerned with exhibit 1 to 4. This is those documents are not the subject matter of this second appeal. Here we are concerned with exhibit 5 to 12.
In this regard, the court has come to a conclusion. Period 3 also substituted that exhibit 1 to 4 are duly issued from the office of the Tinsukia Municipal Board. Period 3 in support of his deposition has exhibited in support of his deposition. He has exhibited. Mark is exhibit 6, the demand register, exhibit 7, the computerized demand register, exhibit 8 and 9 being agreement, renewal receipt, and exhibit 10 and 11, then receipt in the name of plaintiff. This is the other
So
document.
who is witness exhibited these documents?
The plaintiff.
Plaintiff.
Plaintiff. This is the period 3.
So plaintiff has exhibited this exhibit 5 to 12.
No,
1 to 4, and this 5 to 12, this without 3 is exhibited. The official witness has exhibited himself.
Okay.
my lord, the consequential order I have given, my lord, that order 1812 passed by trial court. It says, my lord, that the documents cannot be allowed to be exhibited. This is the order of 1812, my lord, after the passing of the order in CRP. my lord.
Okay. Have you furnished a copy to him?
That is
Yes,
I think I have no idea of this.
Okay.
Like, only a short date may be given because execution proceeding is going on, my lord.
When the next date is fixed?
29, my lord, Wednesday.
29. You file an application there. The
Right.
one RSA is pending.
my lord.
And heard Mr. Gupta, learned counsel for the appellant, and Mr. Gogoi for the respondent. Heard in part, place the matter on Thursday. In the meantime, Mr. Gupta, learned counsel for the appellant, shall bring on record the order dated 18/12/2013 passed by the learned trial court entitled sub number 21 of 2011 by way of an affidavit.
Okay.